On your side, Mr.
Lordship, may I have your kind leave to mention one matter for inclusion in the
Give
list
it.
with the
Give the
non-commercial?
slip.
Let's say commercial item number 1.
This is my application. In this matter, your lordships has already passed an order of stay, in a sense, and directed affidavits to be completed. The affidavits have been completed. Now, the matter will have to be taken up for final hearing whenever it's comments to your lordships.
So all papers are before us. We'll be
No,
here.
I don't think so, my lord. That's the difficulty.
Let's not have multiple hearings. Let's have all the papers.
In petition,
Whoever file it, whoever wants to
in
file it.
petition,
Plain petition আছে তো।
annexure গুলো নেই।
না না ঠিক আছে করি না কোনো অসুবিধা।
Yes, there possibly something is missing.
So you file that within a week or so. Just file a paper book including missing papers.
Very well. তুই করবি তো?
You're on the same side, Mr. Mitra and Mr. Bachawat.
No, not there are three parties fighting each other.
Acha.
Ladai up for respond numbers.
So one,
I will prepare it.
1 week, 10 days. How long we want?
কতদিন লাগবে? 2 weeks.
Dekho. Affidavits have been exchanged as per earlier direction of this court. Paragraph, Mr. Mitro, learned senior counsel representing
My lord, 1 and 2. Plaintiffs, respondents number 1 and 2.
Respondents oblique plaintiffs says that some other papers which were there before the learned single judge or learned trial court are not, have not been annexed to the pleadings filed in this application. Paragraph, as agreed by and between the parties, the appellants shall file a paper book, an informal paper book, including all such papers which were there before the learned trial court and which are not there before us presently. Stop. This will be done within 2 weeks from date. Stop. Paragraph, it is understood that the appeal will be heard out.
Yes.
Along with the application. Stop. Let the matter be listed under the appropriate heading 2 weeks hence.
Yes. 2 weeks hence কত তারিখ হচ্ছে?
But appropriate heading be for dismissal.
If Mr. Shah agrees.
Wishful thinking.
তাহলে বল কি heading appropriate?
No, যাইয়ে। But
Well, 2 weeks is we'll get over on the 9th of September.
so slightly more time because if they file it
Acha.
my lord, within 2 weeks.
ঠিক আছে 2 weeks hence বলো না. It give us a date.
Well, it's maybe on the 16th or 17th if it's
16th
16.
September 16th.
may I request your lordship to keep it on the 17th. 16th I find there's a matter fixed.
17th is not an
18th.
appellate side day, but we can keep it on the
18th in
17th. 18th.
Yes.
September 18th.
Hmm.
Well, let my learned friends indicate to us what are the papers they say are missing, because otherwise, again, my lord, there will be a few.
তো পড়া ধরলে হয় নাকি?
No, no,
No,
no,
no, no.
record.
Mr. Mitra's junior will
Exactly.
help you.
আরে ডেগুলো দেখো, look at it.
দাঁড়া, ওর
You are assisting Mr. Mitro?
After 8, I'm not there.
Mr. Mukhopadhyay is very meticulous. Yes.
But could it be 18th?
No,
Then?
not 18.
18th.
Okay, 16th.
No, 18th. We have said 18th.
18th will not be
He's
there.
not
Oh, I see. Then
22nd, 23rd.
But 22nd,
23rd.
whatever. Nada.
23rd.
Second then, well, 23rd duty ho jayega.
And then we know he'll say last week.
That
But I
brings us
think,
too close
I
to
think
the
not
holiday.
everyone is looking at a puja gift, perhaps. Puja bonus.
Tell us, whatever date.
22nd.
22nd, very good.
কিছুই হবে না
20?
second
22nd.
22 না 22 তাড়াতাড়ি সিল করে দাও নাহলে আবার পাল্টাবে
ঠিক আছে, তাহলে তো অসুবিধা নেই। Interim order shall
22nd is a Monday.
Correct.
23rd in there.
23rd.
Yes. No further changes.
till the response.
তাহলে পেপার বুকটা 3 সপ্তাহ দিয়ে দাও না কি তাড়াহুড়ো করে 3 weeks করে দাও।
Obviously ছুটির পর হবে।
23rd.
একটু কি আছে বাকি সেগুলো তো ওদেরকে জানিয়ে দেয়।
You can not gone. Just send it to them, ask them to.
Oh my God, so the definition of ad interim injunction. I'm sorry. I'm sorry. My application for ad interim injunction was refused on the ground that I had approached the learned court in delay, my lord. There was a delay as per the learned court. Will kindly take the order which is dated 23rd June 2025, my lord.
Madam, 23rd June, refusal,
Yes.
ad
my lord.
interim ex parte,
Yes. my lord.
service, and 30th July was the next date.
Yes. my lord.
What happened?
We had filed the appeal in the meantime. That's why we had sought time.
No, go back.
But the difficulty is, will kindly bear in mind that my only prayer before the learned trial court was that my goods, these are these are the fabricating machines and my materials, steel girders and all. But these are my goods, admittedly. But my goods are there in the premises of the respondent. I only want a receiver to have a symbolic possession because when I had gotten it, they have repeatedly told me pick up your goods in November. On 3 occasions, Millard. That on 3 occasions in November, they had
Nothing.
granted me a termination notice, again reinstated. In December, again a termination notice allowed me to work.
Madam, we have read the order. There's nothing wrong in the order. There was delay. If you were so concerned, you should have approached the court earlier.
I had.
Now,
Will
you
bear
wanted
with me for one moment. Millard.
either then we'll dismiss on merit. We are giving you an option. Because the matter is pending before the learned trial court, we'll say we are not touching this and you can renew your prayer, press your application. Otherwise, we'll dismiss on merits, which will not be good for you.
Millard, yes, Millard, I bow down to what is falling from Millard. Only one thing, Millard, what was not before the learned trial court was that we had actually filed a suit before the learned Asansol court when it was advised to the client that there's an arbitration clause and this suit would not lie, and therefore Millard, the delay was there. Millard, I've annexed the application. Millard, Millard, we'll see.
Correct. Anything else?
Millard will then grant me
We'll dismiss it.
of this application, Millard.
Hmm?
But the application, the section 9 application
Yes.
which I filed, the
Follow it up.
proposal of
Yes, that we'll say. No problem. Elekho, this appeal is directed against an order dated June 23, 2025, whereby learned judge commercial court at learned judge, commercial court at Rajarhat, North 24 Parganas, in Miss Arb bracketed com -25/2025, refused to grant an ex parte order of injunction. Stop. Ex parte order of injunction on an application filed by the appellant herein under Section 9 of the Arbitration and Conciliation Act, 1996, paragraph. We have seen the order of the learned commercial court, learned trial court, stop. The learned judge refused to pass an ex parte order as the learned judge was of the view, and in our opinion, rightly so, that the appellant oblique petitioner did not approach the court with due diligence. Stop. The conduct of the appellant did not show any urgency. Stop. Hence, ex parte order was declined. Stop. The learned judge directed service on the respondents in the Section 9 application and posted the matter on July 30, 2025. paragraph, we are told by learned advocate for the appellant that since the appeal had been filed in the meantime, comma, adjournment was obtained before the learned trial judge. Paragraph, since the Section 9 application is pending, comma, we are not inclined to entertain this appeal against the refusal of the learned trial court to pass an ex parte order of injunction. Stop. We leave all points open for the appellant to urge before the learned trial court. Stop. We clarify that we have not addressed the merits of the case at all. Stop. We request the learned trial court to expedite hearing of the Section 9 application and take the same to its logical conclusion as soon as possible. Disposed of. Next paragraph.
Deeply obliged.
जूनियर मेरा संजीव चक्रवर्ती
এটা ভলিউম আছে তাই না? তিনটে ভলিউম আছে তো?
তিনটে না দুটো ভলিউম আছে
তিনটে ভলিউম।
তিনটে
নলেজ
যেমন আছে ভালো
আছে। আমি এখন নোট বলে বেশি কথা।
আমাকে ওখানে বলছে যে আমি এবার গেছিলাম সার্কিট বেঞ্চে আমাকে বলছে আপনি ওখানে প্র্যাকটিস করতে শুরু করে দিন
মানে I am for the appeal in
Yes.
file this appeal, I prepare this appeal under section 37 of the Arbitration Constitution Act against the order passed by the learned judge commercial court who rejected my application under section 34 of the Act for seconds award on the ground the application was filed along with a photocopy of the signed copy of the arbitral award. The issue involved is, my lord, whether filing of the application under section filing the application under section 34 of the Act 1996 for setting aside the arbitral award accompanied by a photocopy of the signed copy of the arbitral award is impermissible and held to be liable to be non-est in contemplation of subsection 3 of section 34 or not, my lord. This is an issue involved. Judgment
संजीव कुमार चक्रवर्ती है जूनियर एडवोकेट उसका नाम जैसा
Input order at page 340 of the volume 3, my lord.
मेमो ऑफ अपील तो आता
Memo appeal watch. Order findings.
ঠিক আছে না আমি ও তো নিচে থেকে খুলবেই জানো হেল্প করলাম তো सेक्शन 31 निकाला
প্র্যাকটিস ডিরেকশনে আমরা কি বলেছি বইগুলো ঠিক আছে এটা জাতীয় ওটা না যেটা নোটিফিকেশনটা আছে না নোটিফিকেশন
31
এটা থাকবে কি হবে নোটিফিকেশন হয়েছিল সত্যি তো আমাদের কপি করা উচিত ছিল এটা দিয়ে
এদিকে চলে আসুন निकल गया 31 टेस्ट এদিকে হ্যাঁ চলে আসুন
Yes, Mr. Agarwal, where is the requirement in law?
My lord, we did not take this point. The point was taken by the
Judge,
judge himself.
we find nothing that
In
at
fact,
the highest, even if there was such a requirement, that
The-
would be an irregularity which could be cured by producing a certified copy.
okay. The
There's
court
only
had,
signed
my lord,
no
in fact,
certificate
come to
copy,
know.
my lord. You know,
No, they
all-
did not even offer the learned.
Original. What
My
is
lord,
signed
it is
copy
in
of-
fact that my learned friend did not offer that we will file the certified copy or a signed copy.
I heard many appeal of the application of the
In fact,
Union of India has also citizen on this ground.
No, so therefore let us remand it.
very well, my lord, let them file a signed copy or a certified
that is
copy
in
of the
the-
award.
Signed copy. You can find.
It has not been decided on merit. my lord.
You were the claimant.
Yes.
Arbitration, you were the
Yes,
claimant.
I'm the claimant.
Nil award.
Yes.
Nil
The
award.
Indian builders.
Nil
Award
award,
is-
your claim
No,
was.
award is I got the award and they also got the counter claim also. Both are there.
Yes, sure.
I'm sorry, my life.
This appeal is directed against an order dated July 10, 2025, whereby an application filed by the present appellant under Section 34 of the Arbitration and Conciliation Act, 1996, was dismissed by the learned judge, Commercial Court, Shiliguri. ওই application, Section 34, like being Miss Arbitration commercial, it was 26 of 2024. Was dismissed by learned such and such. On the ground that the impugned award was not filed along with the application, a statement of truth. Have you looked up those judgments which the learned judge has referred to? Do they say that?
No, sure. The issue is there, my lord. The first judgment.
Show us those judgments.
I brought.
বসে
That-
দেখিনি
The first judgment mainly relied upon the first judgment.
Pragati construction.
Oh, এটা না তো হ্যাঁ ঠিক আছে হ্যাঁ Paragraph 66, 67 is relevant, my lord. And running page 27.
কপি আছে কম্পাইলেশন এক সেকেন্ড দাও না, আমি দিয়ে দেবো। তুমি দেখাও খুটকে, অন্য কপি নেই? কি সাইটেশন আছে? পুলিশ রিপোর্ট।
That was, my lord, they filed without any copy of the award. The ratio laid there, my lord, if a application under section 30 was filed without, there's a without Bhogatnama, without the copy of the award, and without of the statement of truth. The court held that this is application is non-est because you have not filed a copy of the arbitral award.
Mandatory.
So filing of the any award,
Copy chilo ekhane? You had filed a copy of the award.
yes. This is what I'm annexed also. He said I should file a signed copy award in original. The 109 is my the ratio laid down in the Delhi High Court is a defined issue, my lord.
Next case, Continental.
This no continental, my lord, paragraph 21 is the it starts from page running page 40, relevant portion is at page 47. This is here the ratio is absolutely different.
Paragraph.
Sorry, my lord. Paragraph is 21. Last part, my lord, at page 47 is relevant. The issues are different. There is no requirement in section of filing in signed copy of the award. That the award of being duly stamped before such can be preferred. At running page 47. My lord, this matter was before the Supreme Court. Supreme Court, my lord, this is a recommendation before this recommendation still is pending. I show it, my lord. I'll show you that.
So there is no requirement.
There's no record. Well, I just place before lordship the issue before the Honorable Supreme Court. Possession judgment. And there's a recommendation.
We'll see, Mr. Roy. Tell us first, next third case.
Oh, sorry, my third case is, my lord, start from page 48, paragraph 47.
রাখুন সামনে।
This is running page 65. Paragraph 47. When scanned signed copy of the order was received by the petitioner, scanned signed copy of the addenda of the award was received by the petitioner. This is the same was valid delivery of terms of section 31(5) of the Arbitration Act. The law has to keep its pace in tandem with the developing technology. When service by email is an accepted mode of service, sending scanned signed copy of the award to the parties would be a valid delivery as envisaged in section 31(5) of the Arbitration Act. This is also a different thing.
Next, Union of India.
Next, my lord. Yes, not this. At page 73. It starts on page 73, paragraph 17, my lord. This is at running page 77.
Oh, this is just following the first full bench decision. Next, National Agricultural.
Well, this is in our High Court's judgment, my lord. This is here, my lord. Page paragraph 33, page 88. The issue is separate until it is a question of limitation. until this is a signed copy of the award under section 31 subsection
So
5.
for the purpose of limitations.
These are 5 judgments they refer to. The number 6, I have given the other of the judgment of Karnataka High Court. Kindly come to page 90, my lord.
The compilation.
I'm reached now.
Yes.
Page 94. So the judgment is the judgment of the Karnataka High Court, my lord. Running page 94, paragraph 15 and 16. And upon careful examination of the provisional sections report, it becomes evident that while certain requirements have been made mandatory before filing an application for setting aside the award, filing of a signed copy of the award is not one of them.
Yes.
So this is decided in my favor. My lord, I just place your lordship. Other 3 judgments, my lord, that regarding interpretation of statute. But what happened?
It is required.
My lord, can you see the Supreme Court report to the not have.
You must give me the references and
My lord, can you see it is pending with Supreme Court? Can you see the judgment? Judgment 2025 7 SSC is 1
5-7 SCC.
and 8 due to the topic 2. You also kindly state come to paragraph
Page number?
185. This is okay. Please. 1. Paragraph 185 at page 105, my lord.
Read a sheet.
The 1940 Act in our country had been express power to modify. When the Act was enacted for reasons based known to the legislature, the power was not incorporated. T.K. Viswanathan Committee, which examined reforms of the Act, has recommended for the incorporation of the provision in report, but as yet the legislature has not enacted the provision to modify. Can you see the recommendation first one? It is proposed to amend Section 34 to insert a new subsection 1A to provide that an application for setting aside award shall be accompanied by original award, and where the parties have not been given the original award, they may file a copy of the award signed by the arbitrators. It is still in a
Considerations.
but these are reports. These are the reports, my lord. These are the so it is, my lord. Learned judges, my lord, imported substance 5 of the section 31.
All right, we'll remand it.
My lord, may I just only one thing I would like to point out. I am not kindly come to the 3rd page of the order. My lord, that is in the bold. Lord, my learned friend had wanted to make a copy of it and filed it. He did not intend to give the copy which has kindly come to this paragraph.
3rd page.
3rd page. In the 3rd paragraph. Lastly, with regard to the objection numbers 1, 2, 3, this court is of clear opinion that in absence of a clear procedural layout for preferring a petition under section 34 of the ACA 1996, in the provision itself, section 34 of the ACA 1996 should be read and comprehended in conjunction with section 31 in bracket 5 of the ACA 1996 that provides for furnishing a copy of the award by the learned tribunal to the parties to the arbitration. Read and comprehended thus, it is abundantly clear that a party to a petition under section 34 of the Act must prefer the petition along with whatever copy has been furnished to her, him, by the learned tribunal under section 31(5), regardless the same being an ink signed one or a photocopy of the signed copy with due authentication thereof, or a certified copy of authenticated copy, or an attested copy or an e-signed copy along with email of the authentication thereof, and not by making a copy out of the same that is unsigned, unauthenticated, uncertified, and unattested photocopy, Xerox copy,
For interpretation.
without any explanation for acting as such.
Correct. একটা কপি ফাইল করলেই হবে এসো
Never, my lord, they ought to have given
Yes,
an
I'm ready to.
authenticated copy.
Now they,
That is what the court is asking, my lord. And then the statement of truth was also not there. I'm not saying it is a curable defect. They should have
No, they're not
provided.
rejected.
I'm saying that is a curable defect, but the court wanted an authenticated
I have
copy of
I have the photocopy of the signed copy.
ও চলে গেল দেবজ্যোতি আচ্ছা কি হয়েছিল কি বলেছে on the ground
আমাকে
that it
judgment গুলো
dismissed by learned judge Shri stop. The two grounds on which the application was dismissed are firstly, comma, the impugned award was not filed with the application, and secondly, comma, the statement of truth capital under order 6 rule 15 capital A of the CPC bracket A as amended by the Commercial Courts Act, comma 2015 bracket closed, was also not filed. Stop. According to the learned judge, comma, non-filing of the aforesaid documents made the application non-est in the eye of law. Stop. You can tell with the purple operation. You have honest in the eye of law. And accordingly, the application was dismissed. Paragraph. Being aggrieved, the applicant has come up by way of this appeal. Paragraph. We have heard learned counsel for the parties. Stop. Learned counsel for the respondent, in her usual fairness, submits that the point of non-filing of the award,
Non-filing of signed copy of the award.
signed copy of the award, was not taken by the respondent, but was a point which the learned judge himself raised. Paragraph. Section 34 of the 1996 Act reads as follows. The other way. Paragraph. We do not see any mandatory requirement of filing the original award or a signed copy of the award along with an application for setting aside an arbitral award. Stop. Paragraph. The learned trial court relied on certain judgments, and in particular, the judgment of a full bench of the Delhi High Court in the case of একদম গোড়ায় যেটা আছে এক নাম্বার হ্যাঁ etc 2025 SCC online Delhi 636. Stop. We have gone through that judgment. Stop. কোন প্যারাগ্রাফ গুলো বলো রে?
67. Running page 27. One.
What that judgment holds is that filing of a copy of the impugned award is mandatory. Stop. It does not say that the copy has to be a signed copy or the original award or the signed copy. Stop. The relevant paragraphs of that judgment are reproduced here under
Baba.
page 28, running page 27. আপনার ফোন ওটা খুব ভালো, রবীন্দ্রসঙ্গীতটা খুব ভালো।
Bye.
Running page 27, paragraph 66 or 67. Paragraph. Other decisions were also referred to by the learned trial court. Stop. However, since we have referred to the full bench decision, other decisions of the Delhi High Court. We have referred to the full bench decision, comma, it may not be necessary for us to discuss those decisions. Stop. Paragraph. On the other hand, learned advocate for the appellant, learned senior counsel appearing for the appellant, pardon me, learned senior counsel appearing for the appellant drew our attention to a judgment of the Karnataka High Court.
এর কপিটা আমাকে দেবেন কর্ণাটক হাইকোর্ট। আরে আমাকে কপি তো দেবেন জাজমেন্টের।
Page 90. হ্যাঁ, যদি কনস্টাইটেল স্যার পেজ 90 থেকে নেবে, ঠিক আছে? ওখানে দেখবি এটা রিপোর্টেড নয় তো, WPO নাম্বারটা দিয়ে দেবে। হ্যাঁ, জাজমেন্টের ডেট, জাজমেন্ট ডেটেড October 5, 2023, হ্যাঁ, delivered by a learned single judge in WP number 105457 of 2023. Stop. At paragraph 15 of the judgment, comma, it was observed as follows. Paragraph 15 টা পাবে page 94 এ। Next, learned senior counsel further drew our attention to a judgment of the Honorable Supreme Court, a judgment of the Constitution Bench, the judgment of a Constitution Bench of the Honorable Supreme Court in the case of a Motada Gayatri Balasamy. It's a case 2025 7 SCC 1. Stop. In particular, our attention was drawn to
185 at page 105.
paragraph 185 of the reported judgment.
Recommendation.
From where it appears that the recommendation that Dr. T.K. Vishwanathan committee, which was set up for considering and proposing amendments to the Arbitration and Conciliation Act, 1996, recommended, inter alia, that a new subsection be inserted in section 34 of the Act to provide that an application for setting aside an award under subsection bracket A1 shall be accompanied by the original award, and where the parties have not been given the original award, they may file a copy of the award signed by the arbitrators. Stop. It appears that such recommendation is under consideration and the same has not yet been incorporated in the statute paragraph. In view of the aforesaid, we do not see that there is any mandatory requirement to file a signed copy of an arbitral award along with an application for setting aside such award under section 34 of the 1996 Act. Stop. Even the full bench of the Delhi High Court says that a copy of the award, within must accompany the setting aside application. Stop. Paragraph. We are also of the view that that non-filing of the original award or a signed copy of the award along with the setting aside application is a mere irregularity which can be cured. That's true. দরকার নেই।
It is not.
দরকার নেই। Insofar as the non-filing of the statement of truth, orders under Order 6, Rule 15, capital A of the CPC, bracket as amended by the Commercial Courts Act, bracket close, is concerned, the same is an irregularity which is curable. Stop. The appellant oblique applicant should comply with the aforesaid requirement. Stop. Paragraph. In view of the aforesaid, and since the application under Section 34 of the 1996 Act was not considered on merits by the learned trial judge, we set aside the order under appeal and remand the matter back to the learned trial judge for deciding the application on merits upon hearing both parties and upon filing of statement of truths by the
Subject compliance.
appellant oblique applicant.
Yes.
Stop. Oh, acha. The statement of truth should be filed within 2 weeks from date.
Yes.
2 weeks from date. And the learned trial court can thereafter hear out the application. Paragraph. We clarify we have not touched the merits of the case. So the learned trial court shall decide the application in accordance with law. In accordance with law.
But only one submission. Lord, let my learned friend give me the citations
Yes.
of the judgment and the copy.
For that, we did not
Not
pass an order, Mr. Manoj.
I just
Senior, you are both senior counsel
yes,
now.
I have not taken this point.
আচ্ছা, Mr. Manoj, please, senior advocate করে দুজনই senior, কেস খেয়ে যাব। দুজনই senior advocate, senior না লিখলে কেস দেবে আমাকে।
Yes, ma'am. দিদি।
ওইটা একটু দিয়ে দিন, আমি জেরক্স করে নিই।
হ্যাঁ, কোনটা কি চাই বলো না। আচ্ছা, ফেরত দিয়ে দিও কোর্টে আবার।
পেলেই ম্যাডাম
রাখো সেটা।
এটা তো নেই।
কোথায়
কোনটা আচ্ছা, আপনি নিয়ে নিন, আপনি নিয়ে নিন, পুরো ফাইল নিয়ে নিন, রেকর্ড স্টিচ করা আছে।
হ্যাঁ,
আরে খুলে নিতে হবে না এখান থেকে, আপনি নিয়ে নিন, ফাইলটা রেখে নিন, আপনার কাছে পরে পাঠিয়ে দেবেন, কোনো অসুবিধা আপনাকে দেয়নি মেমো কপিটা, আপনাকে মেমো কপিটা দেয়নি।
I'm led by Mr. Kundu, my lord. It is linked in port number 1, my lord. He has humbly requested, can it be taken up at effective, my lord?
Are you serious, sir?
My
On
lord,
your request, we have fixed a matter.
my lord, he has humbly requested, my lord. He is replying, his matter has been going on since Thursday, my lord. He is replying to that.
Sorry, sir, sorry. We can accommodate to an extent, to a degree, not
My lord,
beyond
I can
that.
understand that, my lord.
দেখতে পাচ্ছি না। 12:30 কানটা তো কি Sorry.
Then
Sorry. On the although this matter was specially fixed on the request of the appellant, adjournment is sought for on behalf of the appellant. Paragraph, let this matter stand adjourned for a week. You are on the other side. This is unfortunate, Mr. Mitru. As it is, we are under a lot of pressure.
my lord, I can understand, my lord.
He has a junior, he's a senior advocate. Who is his junior?
My lord, Mr. Nondi, everybody is there, my lord.
Hmm?
Everybody is replying to that quote number
No,
one.
then,
My lord.
sorry. And we are not fixing any time. Daku, next. Daku.
Commercial item number 4.
But I beg to appear for the respondent number 1 in this matter.
This is my appeal.
Prime projects, yes.
It's my appeal. My lord, appeal from an
All
order.
respondents are here?
Yes, for the respondent number 2.
How many respondents are there?
2 respondents are there.
The appeal is from an order by which the learned court below was pleased to refuse extension of the interim order which was already granted on the ground that the agreement is not registered.
Impugned order is dated?
Well, at 4th of August 2025, it is at page 215, but your lordship takes a look from the memorandum of appeal.
What happened on 20th of August?
It was adjourned at our instance.
Our written objection on that day. The objection is on record. On their prayer, it has been adjourned.
Because we had already preferred the appeal, my lord, so yeah.
Yes.
Yes, well, it's section 49 of the Registration Act clearly prescribes that in case of an action for specific performance of a contract, non-registrations will not be a bar.
What was the order you obtained? Injunction restraining them
Them from creating any third-party interest. Because the facts are, the petitioner before your lordship is a developer who had entered into a development agreement as joint venture development agreement. But as per the clause of the development agreement, the payment terms, we had made over the 21 lakhs, which was the first tranche, which had accrued as on that date. We had paid that. They were supposed to hand over possession of the property. It's a one-storied structure.
They're owners.
They are the owners. It's a cooperative society. It's a one-storied existing structure which has to be demolished, and a new building was to be constructed. Possibly they have got some better terms from somebody else, so they were refusing to hand over possession, and also they have remitted an amount of 2.5 lakhs to my bank account, which I have returned. So there is when the dispute had started. We filed a Section 9 application because the arbitration agreement is there in the housed in the development, this joint venture agreement. We get an order of injunction. On the returnable date, that order is vacated on the ground that this is unregistered, so it's an illegal agreement, and we will not be getting the extension. That is the sole ground on which it was vacated. Now, your lordship would see from my pleadings, and I shall show 2 paragraphs, that my claim is for specific performance. In paragraphs 32 and 38 of my Section 9 application, I had pleaded that my claim, my remedy, my relief, which I will be claiming in the arbitration, is for specific performance. But in aid of that, for interim measures of protection under Section 9, we have filed this.
Can you get specific performance of an unregistered development agreement?
Perhaps, yes. May I indicate, subject to what your lordship's interpretation is, kindly see Section 49 once of the Registration Act.
Hey. দাও একটা বার করে দিয়ে চলে গেলে
May I place it? Effect of non-registration of documents required to be registered. No document required by Section 17 or by any provision of the Transfer of Property Act to be registered shall. Then, your lordship would kindly omit A, B, and C. Kindly seize the proviso. Provided that an unregistered document affecting immovable property and required by this Act or the Transfer of Property Act to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act, or as evidence of any collateral transaction. But we are on the first part of the proviso, that it can be received in evidence for a suit for specific performance. This is my only contention, nothing else. Now, your lordship would see where my pleading is in my Section 9, because now the statement of claim stage has not yet come. In the Section 9, what is my pleading? Your lordship would kindly have a look at. I shall trouble your lordship with only 2 paragraphs, if your lordship's permit. Kindly takes a look at paragraph 32 first.
Any authority on this aspect?
Yes, my lord.
On this proviso?
On this proviso, yes, my lord, but only to persuade you. Otherwise, we have other Supreme Court authorities. Specifically on joint venture development agreement, we have got a Bombay High Court single bench judgment, just to persuade your lordship. I know, but other authorities I shall cite. But this is specific to my lord. The development agreement, joint venture development agreement, and specific performance.
Unregistered.
Unregistered, Section 49. This is a specific on this agreement.
বেটা আমার সঙ্গে গিয়েছিল এতে ইন্দোনেশিয়া।
My lord, we'll kindly have a look at the first portion, my lord, in fact, the first paragraph, that there is a section 9 petition. But here, prayer A is also in the first page restraining third party rights. So it's identical to our case. Paragraph 7 is the development agreement. Kindly see, my lord, paragraph 7. This is for breach of a development agreement. Now, your lordships would kindly have a look at paragraph 12C, which is the objection raised that the unregistered agreement, so no order can be passed. And thereafter, my lord, on this issue, the ratio, my lord, the finding at paragraph 29 and 30, my lord, if your lordship kindly takes a look at page 18 of this judgment. May I place it, my lord? The last argument canvassed by Dr. Tulsapurkar is that no relief can be granted to the petitioner as the agreement dated such and such is not a registered document. I find no merit in the aforesaid argument either. Section 49 of the Registration Act reads thus, the section is quoted, then paragraph 30, your lordship. As can be seen from
Yes,
the...
what other judgments you have?
Yes, my lord. May I place 2010 volume 5 Supreme Court cases 401. This is on import of, my lord, section 49. On 49 proviso, where an unregistered agreement for sale was sought to be received in evidence in an action, my lord, for specific performance. Kindly takes a look at paragraph 12, which decides the issue. Paragraph 11 quotes section 49, then paragraph 12. May I place it, my lord? The main provision in section 49 provides that any document which is required to be registered, if not registered, shall not affect any immovable property comprised therein, nor such document shall be received as evidence of any transaction affecting such property. The proviso, however, would show that an unregistered document affecting immovable property and required by the 1908 Act or the Transfer of Property Act 1882 to be registered may be received as an evidence to the contract in a suit for specific performance or as evidence of any collateral transaction not required to be registered. Then, my lord, placidum F, my lord, such unregistered sale deed can also be admitted in evidence as an evidence of a collateral transaction not required to be effected by a registered document. When an unregistered sale deed is tendered in evidence, not as evidence of a completed sale, but as a proof of an oral agreement for sale, the deed can be received in evidence, making an endorsement that it is received only as evidence of an oral agreement of sale under proviso to section 49 of 1908.
Yes.
My lord, just to show, my lord, I do not intend to multiply judgment, but just to show that even this is the latest position, I also have a 2023 volume 10 Supreme Court cases. Page 725.
Does it refer to the earlier one?
I will kindly give. No, it does not. Now it kindly comes to paragraph 23. 22 section is quoted, then 23.
It says what the section says. Yes.
Now, my lord, one authority. 23. My lord, one thing, my lord, I should point out, my lord, the judgment which was relied upon by my learned friend and which was the basis of the order, my lord, is, my lord, 2018 volume 12 SCC 354. That was the judgment referred to in the impugned order, on the basis whereof my interim order was refused to be extended. Kindly takes a look at this judgment. This, in my humble understanding, subject to my lord's testing.
Balbir Singh.
Yes, my lord. Commissioner of Income Tax was Balbir Singh Maini. This, in my humble understanding, my lord, perhaps, my lord, deals with a completely different situation. But this was dealing with, my lord, kindly takes a look at what issue is there. Paragraph 3 at page 359 of the report. What was the issue before the court? P small Roman 1. Whether the transactions in hand envisage a transfer exigible to tax by reference to section 247(5) of the Income Tax Act 1961, read with section 53A of the Transfer of Property Act. This was the issue on which it was delivered that an unregistered agreement cannot be, my lord, looked into. In light of, my lord, section 53A of the Transfer of Property Act, here the court was not even deciding an issue of section 49 proviso.
What is the finding?
Yes, my lord. Your lordship would kindly have a look at, my lord, paragraph 21st, where, my lord, the Honorable Supreme Court was, my lord, quoting 53A, because that was the issue involved. Then your lordship would kindly have a look at paragraph 22 at page 368 of the report. 22 and 23, my lord.
Yes, goodness or badness. Absolutely right. যেটা চাই যে কোনো মতে খেতে পারে তাহলে কিসের ইন্টারেস্ট Yes.
Just for the completeness of my arguments, my lord, if your lordship kindly looks at the pleadings, I shall trouble your lordship with only two
One
paragraphs.
second.
I'm sorry.
Yes, pleadings.
Yes, my lord. Kindly takes a look at the second volume, my lord, where my section 9 application is annexed.
Yes.
My lord, paragraph 32 at page, my lord, 169.
Yes.
My lord, we'll kindly have a look at page 169.
One
169.
160.
169, my lord.
169.
Paragraph 32, the last sentence. The petitioner is entitled to specific performance of the joint venture agreement dated such and such and damages for wrongful breach of contract. And also, my lord, paragraph 39. Because now, as per the amended provisions of the my lord, Specific Relief Act, I'm entitled to both specific performance and damages. So, my lord, this is my pleading.
Hey. So let us hear the other side.
Yes. No, by the impugned order, the agreement was said to be illegal. That is one of
Said
the
to be?
illegal. So that is one of.
Yes.
Lord, we are at an ad interim stage. So, Lord, let us consider their application to be true and correct for all aspects. Lord, first point, I'll answer, meet the points, Lord, taken by Mr. Gupta, Lord. First of all, Lord, kindly comes to, Lord, the cause title of the application. That your Lordship would get at page 154. 155. I am appearing, Lord, for respondent number 1. And he has claimed one Golok Ranjan Bose to be the president. Although Golok Ranjan Bose has been specifically, Lord, individually made a party in that aspect. Now, under section 19 of the West Bengal Societies Registration Act, Mr. Gupta indicated it's a cooperative society. It's under Lord West Bengal Lord Societies Registration Act. Now, under section 19, Lord, it is the secretary or the president who has to be made by name of the party, not the society. Lord, here they might say that Lord Golok Ranjan is the person concerned. I have made a party. Now, Lord, kindly comes to page number, Lord, 101. My Lord, is kindly got it, Lord. The Lordship will find that there is a dispute between Lord, this Golok Ranjan, my client, and Milord Mr. Gupta's client is also there. In 2023 June, the suit was filed. That's a part of the petition as well. Your Lordship would see from the cause title, I have described Meghnad Mondal as the secretary. Similar, he was aware it's a registered society. He was aware of this fact because he was a party himself.
Yes.
Despite that, my lord, he describes the application in the way my lord I had indicated to your lordship. Now, my lord kindly comes to the next part, that is with respect to the urgency that they have pleaded. Immediate urgency, my lord, suddenly the urgency has cropped up. My lord kindly comes to page 130.
Now, no, correct. These are not the grounds on which the learned court vacated.
Correct. Not this is, I am indicating this to your lordship only for the reason that not at ad interim stage, from the plaint, it is evident that they are not entitled to any interim order. Lord, with respect to the argument made by Mr. Gupta, I'll come to that.
Mr. Kormukar, why should we at all go into all these points which were not argued or
Very-
decided by the learned judge?
very- Lord, then let us come
Learned
to
judge vacated the order only on the basis that it was unregistered and therefore illegal.
Lord, kindly comes to then section 49 of the Registration Act.
If we remand this matter
My lord.
back, you will be entitled to urge all points.
Very well. I have understood what is falling from your lordship. Kindly, my lord, comes to section 49.
49.
49 of the
Yes,
Registration
yes.
Act. The proviso part. Provided that an unregistered document affecting immovable property and required by this Act or Transfer of Property Act 1882 to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of such and such. This is very important. No, there is an omission your lordship would find. Omission was made in 2001. The omission was made by Act 48 of 2001 on September 24. Previously it read as, or as evidence of part performance of a contract for the purposes of section 53A of the Transfer of Property Act. Lord, here today we are before your lordship not arguing a case where Lord, an agreement for sale Lord, is sought to be Lord, enforced. Lord, there's a difference between an agreement for sale asking enforcement and there's a development agreement. The question of enforcement of a development agreement will arise only after Lord, it sees the light of the day. The interest created, my lord, on the property, my lord knows much better than me. My lord was a part of that division bench, a special bench. Lord, the interest in the property is created by virtue of the development agreement once that agreement sees the light of the day. Till the time it is registered, Lord, the question of Lord having any right, parties Lord averring or asserting any right does not arise at all. This, Lord, your lordship would kindly read. This will kindly
Mr.
read, my lord.
Kormukar, you are asking us to decide his rights finally
No,
at this stage.
Lord, I am only answering his argument with respect to Lord registration and
Today, there is an arbitration clause
my lord,
in a contract,
my lord,
albeit unregistered.
my lord.
The contract, the arbitration clause need not be stamped.
Very well.
So prima facie, he has a case to go for arbitration. Correct, correct. We are deciding nothing on merits. And as you know, this section 9, even if we pass an order, or maybe we won't pass an order, we'll remand it to the trial judge. it remains valid for what, 90 days or something?
90 days thereafter, my lord, 9(3) has to apply. They have to
Yes.
apply.
So we'll say nothing on merits, it doesn't become illegal.
But
Or
it's the
at
question,
this stage, one cannot say with any
Lord,
degree of
Lord,
definitiveness.
it is not the question of illegality.
At this stage, one cannot say with any degree of definitiveness that his specific performance prayer is bound to fail. Bound to fail.
Not the question of specific performance. That's not what I'm trying to impress upon your lordship. Not the question of not this effectiveness or not specific performance will arise in a situation.
Come back at 12, 2.
Lord, may I come back tomorrow, Lord, in that case?
Why we could finish it or why
Lord,
tomorrow?
I have some difficulty, Lord.
No, difficulty is some other case you have. Now, this
Very
is not
well.
right. This is
Very
not right. Chalo. You want to say something? Mr. Mukherjee? Which one?
Item number 6. Mr. Bachwan is not arguing.
Oh, hotel music.
Two hotel matters next. After that, hotel Ratin. That your lordships pointed.
Lord, may I have my lord's kind leave, Lord, to mention item number 5, Lord. It's appearing with defects, Lord. But we have not been informed of the defects. What are the defects?
Check up what the defects are.
Lord, we have checked up. I am for the respondent.
Who will inform you?
Lord, from the filing section, because this is an online filing. This matter has been filed.
That is the rule. They will inform you, or it's up to you to find out.
No, Lord. This is what he has.
No.
Very,
What
very well, Lord. We shall find out.
You want us to adjourn the matter so that
Yes,
you can
Lord,
look
yes,
into
Lord.
it? What, not this week or what?
Not this week, Lord. We shall come upon Monday.
One thing, I am for the respondent, my lord. They have filed a stay application, then we will file affidavit in opposition.
Let the matter appear.
Let
This
it
right now
present be cured. Not this week,
Not
put it
this
up, Panch. Take the file out and see what the
very
defect
well,
is.
Lord. We shall. Grateful.
continuing চলছে Milord,
Yes,
permitted Milord to now to carry forward Mr. Kormkar's.
yes.
Milord, I will only answer, Milord, so far as regards the point which has been agitated before the Milord trial court for the purpose of vacating, or rather, Milord, not to extend the interim order. Milord, the Milord proposition of law, my lords is well aware, Milord, that yes, even at the time of each and every extension, the court has to apply its mind. And if I can demonstrate before your lordship that the initial, Milord, the document by virtue of which the party are, Milord, seeking any protection before this honorable court, and that is not a valid document in the eye of law, no interim relief can be granted, Milord, in aid of that. Milord, that is settled. Now, Milord, my learned friends answer so far as regards the non-registration is concerned, section 49. Milord, Mr. Kormkar has already placed in 2001, Milord, what happened? There is an insertion under section 70 of one, Milord, particular section 17(1) capital A, and there is omission done under section 49 proviso. So omission, your lordship has already noticed, that was done, that the language that was there in the section 49 or as evidence of part performance of contract for the purpose of section 53 capital A of the Transfer of Property Act 1882. This was there, Milord, in 49 proviso. This was being omitted in 2001 amendment. Now it kindly takes up, Milord, what is being inserted. Section 17, if you sorry, Milord, section 7. So section 17(1) capital A. If your lordship once takes up, Milord, 17(1) capital A. This was also inserted, Milord, in 2001 amendment. And Milord, these two, deletion and incorporation, has been taken care of by the Honorable Supreme Court. 1A, Milord, is the document containing contract to transfer for consideration any immovable property for a purpose of section 53 capital A of the Transfer of Property Act 1882 shall be registered if they have been executed on or after the commencement of registration and other related laws amendment act of 2001. And if such documents are not registered on or after such commencement, then they shall have no effect for the purpose of the said section 53 capital A. So, Milord, these two things has been done simultaneously. So your lordship knows, Milord, after 2001, that's why every joint venture development agreement used to got registered. And the effect of non-registration, your lordship knows, this is an incurable defect. Like a curable defect, your lordship knows better than us that yes, when a stamp duty has not been done, section 35 is there to take care of.
What happens if it is impounded and
It cannot be,
why?
Milord, yes, Milord, I'm coming. That argument was made, Milord, before the learned trial court also. Milord, impounding is something which is a curable defect as per section 35 of the Stamp Act. But registration, your lordship, I will immediately take your lordship to the next provision. Section 24 is there. Section 24 provides, suppose, Milord, today we have executed a document which is compulsorily registrable. The time limit has been prescribed under the Indian Registration Act. By that time, you have to made it presented before the registering authority and got it registered. If that time lapse, there is no condonation. So it's an incurable defect. So this cannot be cured subsequently. Subject to correction, now your lordship takes up, Milord, section 24 once. Sorry, Milord, section 23. Time for presentation of documents. Has your lordship, Milord, got it? Yes. Subject to the provisions contained in section 24, 25 and 26. No document other than a will shall be accepted for registration unless presented for the purpose to the proper officer within the 4 months from the date of its execution, provided that a copy of the decree or order may be presented within 4 months from the day on which the decree or order was made, or where it is appealable within 4 months from the day on which it becomes final. So, Milord, any instrument which has been which is not declared to be compulsorily registrable instrument, from the date of his execution, it has to be presented within the time limit prescribed under section 23. So today, I can demonstrate from their own document that this becomes an incurable defect. They cannot cure it today. Now, whether it is as per Mr. Gupta, Milord, section 49 proviso even is taking aid of him, even after amendment of deletion and incorporation. For that, Mr. Gupta has relied upon 3 judgments. I will demonstrate before your lordship the 3 judgment deals with a case of agreement for sale of a transfer of an immovable property. The agreement for sale, the departure is there till today. But so far as regards the interest with regard to the joint venture development agreement is concerned, kindly now my learned friend has distinguished 2018-12. 2018-12 is not an authority under the Income Tax Act only. Because kindly now takes up once section as 2018-12 Mr. Gupta has handed over, which has been relied by the trial judge. And then I will take your lordship to the order impugned. Because my lord is prima facie is of the opinion whether at this stage some of the observation can affect his right in a future date when he may be relegated to the arbitrator. But I will come to that also. Because today we are on a aspect whether any interim relief can be granted in aid of this document. After all, this is the instrument which in future he is going to ask for specific performance. Now, my lord, kindly takes up this. My lord, I will not trouble your lordship by reading, my lord, the entirety, my lord. It starts with, my lord, kindly takes up paragraph 5 once. Paragraph 5. Why I say, my lord, this is an authority under this law, because my lord, whenever your lordship is considering a judgment, your lordship has to come to what was the facts placed before the court and under which facts, my lord, the court has curled down a ratio. Now, my lord, kindly takes up paragraph 5. ডেভেলপমেন্ট এগ্রিমেন্ট করতে হবে প্রমোটারটা তো বটে paragraph 5 not kindly once looks at, it's a case where the member of Punjab Cooperative Housing Building Society executed a tripartite joint development agreement. But in short, Milord, it has been mentioned in many times JDA. It's joint venture development agreement. Milord, under that conspectus, the land was proposed to be transferred for the purpose of making construction thereon, and certain amount was being paid by the developer. An agreement was entered into, this tripartite agreement, which remains not to be registered. So, my lord, it's an exactly similar case which has been portrayed before your lordship also. Kindly now turns over and comes to, my lord, kindly takes up, my lord, page, my lord, it's paragraph, rather paragraph 21. Kindly takes up, my lord, paragraph 21. I will only just, my lord, show before your lordships that, my lord, paragraph 21, section 53, capital A is being, my lord, considered by the Honorable Supreme Court. Kindly turns over the page. I will show before your lordship, my lord, the next provision has been considered, that is 17(1) capital A. That insertion, my lord, which I have shown before your lordship. And immediately thereafter, section 49, including the proviso, has been considered. So these three amendments have been called out, and paragraph 23, what the Honorable Supreme Court is saying. Lord, may I place, my lord, this paragraph only. The effect of the aforesaid amendment is that on and after commencement of the Amendment Act of 2001, if an agreement like the joint venture development agreement in the present case is not registered, then it shall have no effect in the eye of law for the purpose of section 53 capital A. In short, there is no agreement in the eye of law which can be enforced under section 53 capital A. Now, my lord, of the Transfer of Property Act. This being the case, we are of the view that the High Court was right in stating that the order to qualify as a transfer of a capital asset
Yes.
Lord, the language latter portion of that paragraph again quoted, Milord, I will not trouble, Milord, kindly, Milord, allow me to read that portion. This being the case, and it is clear that the said joint venture development agreement was not registered, since the joint venture development agreement has no efficacy in the eye of law, obviously no transfer can said to have taken place under the aforesaid document. Since we are of deciding the case in this legal ground, it is unnecessary to go into the other question decided by the High Court, namely whether under the joint venture development agreement possession was or was not taken, blah, 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 my lord, other point. My learned friend can.
Right.
Lord, here, my lord.
Transfer of
Oh, I'm
rights.
sorry. Here, my lord, I am joining an issue. Mr. Gupta, in reply, can very well argue that, look, this is for the purpose of 53 capital A. So we are not interested even 53 capital A, but we can enforce the agreement so far as regards other purpose is concerned. But again, coming back to 53 capital A, what he cannot be permitted, he cannot protect or defend a possession in respect of the immovable property. And what he has got ex parte ad interim, he got a protection in respect of the immovable property, which is not permissible under section 53A. So he can argue that very well, I have given 25 lakhs or 21 lakh, protect me for that. For that, in aid of that, he has not prayed for an interim order in respect to that protection. He has prayed for an interim order in respect to the property in question, which is exactly barred created under 53A. He cannot defend or protect possession until and unless the document is registered. So here is exactly case where he is asking for an injunction in respect of an immovable property, which is barred under 53A. And the Honorable Supreme Court has also made it clear. If it is non-est, then he cannot protect or defend any right touching to the immovable property. I am not arguing, my lord, before your lordship, whether this respondent number 2 at all can represent the society or not. That is something we will thrash out before the, my lord, court below. We have already used our opposition. Now, my lord, my learned friend has relied upon 3 of the judgment with greatest respect, my lord. 3 of the judgment I can show before your lordship.
Agreement, it's in the nature of a license to develop, or
I am bow down, my lord. It's in a nature of license to develop with a rider to, my lord, create a third party interest like in respect of a developer's allocation.
But if it is in the nature of an interest, then there is no transfer of.
No, my lord, it is there. It is there. My lord, like a joint venture agreement, my allocation will be this much, your allocation will be this much. After the agreement, after the development work being done, you are left free to transfer your allocation. Exactly same, my lord. Subject to correction by Mr. Gupta, there is no quarrel on that. Otherwise, I cannot argue that point. That is exactly the similar case. And 3 of the judgment which Mr. Gupta has cited, every judgment is taking care of an agreement for sale of an immovable property. So, my lord, in respect of an agreement for sale, my lord, kindly consider, here it's a development joint venture agreement. My lord, I can say, my lord, even today, before section 11 court, he can ask for an arbitrator to be appointed, matters to be relegated. What he can argue before the arbitrator also. He can argue so far as regards damages is concerned, return of money, interest, whatsoever his claim is. He cannot touch my property by virtue of this particular agreement, which is a defect incurable in nature. And my lord, the learned trial court, my learned friend is saying that some observation has been made, my lord, which is so damaging. My lord, may I place, my lord, only the operating portion of the judgment, because the submission that has been narrated or recorded, that is, my lord, there. My lord, may I read only the operating portion, the finding of the learned trial judge. What the learned trial judge has, my lord, seen after the judgments, upon perusal, my lord, may I place? Upon perusal of the agreement and materials on record, it becomes evident that the petitioner seeks interim protection under section 9 of the Arbitration and Conciliation Act 1996, based on a substantive rights allegedly arising out of a joint venture development agreement dated 30th July 2022. The agreement on its face pertains to the development and sharing of immovable property and contains clauses that deals with transfer of possession, construction right, and financial obligations between the parties, elements which clearly attracts the mandate of
Where's the agreement, Mr.
Yes, my lord. Lord, page 66, it starts.
আমি স্টিকার দিতে পারি পোস্টে
Lord, internal page 7, your lordship will find, my lord, the developer's allocation is being mentioned. Order, impugn order. But my hands are tight. I am not arguing before your lordship, which I can. Today also there are certain clauses which remains a conditional. But this is not an absolute agreement also, because it's a Salt Lake property. It has been mentioned that the owner has to obtain the permission from UD department. There is a clause 21.5 in the agreement that in case you do not able to obtain permission, refund me the money. So today it is not, it's a contingent thing. But thing remains, it's a joint venture development agreement. Ultimately, the developer's allocation has been located there and he has been permitted, Miller, to create third-party interest. My concluding part of my argument will be, my lord,
Yes.
since your lordship is of the
You
opinion,
make your submission. We will also do some work on our own and keep this matter again next Tuesday.
Tuesday call. Acha, very well, my lord. Very well.
Whether this joint venture agreement can be construed to be in the nature of an agreement for sale or transfer of
Yes,
interest in
yes,
property.
Yes, my lord, I understood, my lord, yes. I will try to, my lord, since I am not concluding, I will try to, my lord, assist your lordship on that aspect also. What is the difference in between two instruments?
Also on the aspect of the significance of this at the section 9 stage.
Yes, yes.
Because section 9 is a stage where you do not really enforce the contract.
My lord.
Enforce the arbitration clause. In a sense.
But there is an arbitration clause. That's why I am invoking a jurisdiction for my urgent relief. But Lord, yes, Lord, I will assist your lordship on that
Protect
aspect
the
also.
property.
Yes.
Not like that of
Yes, Lord.
39.
Yes, that's why, Lord, protect the property, immovable property, interest over the immovable property. I will assist your lordship on that aspect also.
Because this would have the potential of non-suiting me completely. So
No, that part
may not
I
be,
have
Mr.
not
Gupta.
concluded.
May not
in the
be.
event it is.
May not be, because your remedy in damages.
No, in damages I'm not. But
remains.
for specific performance.
Yes, if we prima facie find, prima facie, all
Yes,
these
yes,
are prima facie.
absolutely.
Definitely.
And this will not affect your claim, statement of claim or claim in the arbitration. That we'll make clear. In the event we uphold
yes,
learned trial judge. So consider and come back to what extent are these questions also relevant while considering an application under section 9.
See Pharma Shop Traders.
Yes. 2004.
Yes. Section 9.
He is for 2.
Unregistered
I'm for the
section.
And I am for the respondent number 2. I will take a
What is
question
the
in
right
respect to the
that
maintainability of section
that
9
you are
in
going
respect
to
to the
enforce?
commercial code is
Is it a contractual right?
not a joint venture agreement, my lord. The classification has been wrongly given,
No,
and
no.
this is a
Did you argue that before the learned
I
single
have
judge?
taken the written objection, and the point is that
Go and argue there, not before us.
But only one indulgence may I seek, but till such time let them not create anything, because we were enjoying an interim order. We are up against an order by which
already paid. Well, Lordship will kindly record.
so till
that
such time let them not.
I have paid a part of amount. Well, I have.
Mukherjee, we will not pass any formal order. In all fairness, since we are hearing this matter.
Lord, I can assure before your lordship,
Yes.
being an officer of the court, Mr. Gupta
I
need
need
not
not
be
sir, make any
That is enough.
I need not make any.
He should
Had it been a case, Lord, we have done it, Lord, long. It's a 2022 again.
This appeal is directed Shop Chulagada. Against an order dated August 4, 2025, whereby the learned judge, commercial court at Rajarhat, North 24 Parganas, vacated an ex parte ad interim order of injunction that was passed earlier in Miss Arb bracketed com -28 oblique 2025. Stop. Paragraph. The appellant oblique petitioner filed an application under Section 9 of the Arbitration and Conciliation Act, 1996, claiming that the respondents were seeking to act in breach of a joint venture agreement. Stop. The agreement contains an arbitration clause for resolution of disputes between the parties. Stop. On that basis, the appellant had moved the learned trial court ex parte and had obtained an ad interim order. Stop. Paragraph. On the returnable date, the respondents were represented through learned advocates. Stop. Upon hearing both sides, the learned trial judge concluded that the joint venture agreement not having been registered, it could confer no right on the appellant oblique petitioner, that it was illegal, it was an illegal document, and that it could not be enforced. Stop. Since no final relief could be obtained by the petitioner on the basis of such document, he is also partnership, it is also not entitled to any interim relief. Stop. Being aggrieved, the petitioner is before us. By way of this appeal paragraph, we have heard learned counsel for the parties at some length. Stop. List this matter once again on Shamner Mongolbar, for further hearing.
One thing, in the meantime, I have filed a vacating application that is on the record and that has been already served.
Vacating where?
The order is not there.
Order is not there. But we
Hey,
have
no order.
objection.
There's no order.
The latter, yes, it has been.
The order has been vacated already.
Yes. Now, only in respect to the objection that has given before the court, that may be before your mercy. That is required.
I'm grateful.
But only one indulgence could I seek. In the event, my lord, the business of the court does not permit the matter to be taken up on the next day. My lord, I know your lordships do not like, my lord, appearing virtually. But my lord, if the business of the court does not permit, kindly grants me leave to, my lord, appear virtually after that.
No, the problem is the connectivity, Mr. Gupta.
I understand, but my lord, I will
It
not
becomes
be,
very difficult.
I will not be physically present in court due to some medical urgency
Yes.
from the 4th of September till the vacations.
We will take it up on Tuesday, know. Eta kaj koro. We'll ensure we take it up. Kholo, khata kholo. আমি জানি তাই তো Tuesday ফাঁকা roughly shall we keep 45 minutes between the two of you? 12:30.
Great.
So it will definitely be taken up now.
Good.
Marked 12:30 করে দিও.
Excellent.
Item 6.
Yeah.
Managed to make it back. Okay. But on the last day, I was placing not the
Justice
judgment
Ravindra
where
Bhatt.
the vires of the Copyright Act was challenged.
Yes.
But I'm not repeating my arguments not made earlier, but I can summarize. Not
This was the other one.
Your main argument is Justice Ravindra Bhatt's judgment.
yes, that covers it fully. And this blood also covers the situation. That's what I was showing your lordship. The vires was challenged, not the usual points which are taken up. Look, you don't have the right to demand. You don't have the right to charge what you want. You can't double charge, triple charge. Three people can't charge for the same thing. This is a private room. Not all of these are considered. But most issues which need to be taken off are considered. But which usually leaves in these matters. But 2 points. Not before I go back to this judgment. But balance of convenience and whether injunction should be granted at the ad interim stage. But these are the other two points which arise. I'll deal with that very quickly. I've showed your lordship that I have absolute right under the Copyright Act. That right has been considered not in relation to hotel rooms across the world, including India. Not those are already mentioned in the judgments I've cited, not just so as to avoid citing too many judgments, but I relied on that. And then I was showing your lordship this judgment of the division bench of the Delhi High Court, where the not vires of Copyright Act, these amendments not were challenged. And challenged by not the Hotels Federation, not my learned friend is probably a member. So not the point there was also not included this point. If your lordship has seen the first page, not the vires of section 2FF,
Yes.
not that itself was challenged, and that's what is not also not involved here. Your lordship has seen FF was that subsection to do with communication to the public.
1 second.
Yes.
তোমরা প্লিজ এটা পাল্টাও সিস্টেমটা জাজমেন্ট ফাজমেন্ট সব দড়ি দিয়ে বেঁধে দিচ্ছ জাজমেন্ট গুলো একটা আলাদা ফাইলে রাখবে প্লিজ
Yes. But I placed a portion of the judgment, but I'll just start not from the beginning. I won't read all of it, just the important portions. But if your lordship comes to the very first page, but third line, your lordship will find one of the sections under challenge was 2FF. I'll remind your lordship not from the Copyright Act. I'm handing it up to your lordship. 2FF was communication to the public, which will not excluded hotel rooms. So not that was also challenged. And then my lord, I've showed your lordship not the relief sought. And if your lordship would then not come to Lord, and my lord, your lordship will see the rights of IPRS, which is my association, are also not in issue at para 8. If your lordship takes para 8, there is such a plethora. There is such a plethora of precedents on this aspect of law that a more detailed analysis would lead to the inordinate prolixity of the judgment, as we already noted. Broadcast or dissemination of music to the public at large is neither a statutory responsibility nor a duty of a public character. The copyright and performing societies, IPRS and PPL, are an amalgamation of conglomeration of individual owners who are fully entitled to claim the highest premium for enjoyment of the fruit of their labor or intellect subject to any statutory restraint. So, that's the general observation. Then the next portion, which is to do with availability alternate remedy, we are not concerned with. If your lordship then comes to para 14, and I won't place all of it. So, the heading your lordship will find just after para 12, just before para 12 rather, are the provisions of the copyright or the rules ultra vires. That's what's being considered. So, they consider all the ruling judgments, including IPRS versus Eastern India Motion Pictures.
quotation Yes.
Yes, that 15 is a quotation, if your lordship is on that. It's a quotation from IPRS. And just to summarize, so I don't have to go back to the whole thing, but what IPRS did was, it decided that if certain rights, like the music or lyric, is built into a cinema. So, my lord, what happens is there's a singer, there is a my lord, lyricist, there's a musician, all of them come together, there's a recording which merges in the cinema. Then, my lord, as far as the cinema hall is concerned, the lyricist and the my lord, composer do not have the right to stop the song being played in the cinema hall, but only cinema hall. Right. So within the cinema hall, right of the owner of the film prevails. But outside it, Lord composer and lyricists have all rights. That is really what Lord 1977, Lord Supreme Court, which is that IPRS said. And there's a quotation, I won't trouble your lordship, but there is a portion, Lord, the quotation from para 15, it starts at page 8 of the judgment. If your lordship comes to page 9. Lord, just by the way, this matter was argued by Mr. Ashok Sen in the Supreme Court. Your Lordship will find the name. I'll show it to you. On that page itself, in fact.
The
about-
IPRS matter. IPR?
Yes,
Oh.
yes. That was argued by Mr. Ashok Sen. Your Lordship will find that about 20 lines,
Yes, I've already
15
seen
lines down.
Ashok Sen, yes.
And then, my lord, if your lordship sees about the last 15, 20 lines of the, or 15 lines of the judgment, Lord, portion where your lordship will find section 14 is referred to.
Yes.
Section 14(1)(c)(2). On the other hand, a close scrutiny and harmonious reading instead of mechanical construction of provisions cannot but lead to the irresistible conclusion that once the author of a lyric or a musical work parts with a portion of his copyright by authorizing a film producer to make a cinematographic film in respect of his work and thereby to have his work incorporated or recorded in the soundtrack of a cinema film, the latter acquires by right of 14(1)(c) on the act of completion of the film a copyright which gives him the exclusive right inter alia of performing a work in public, i.e. to cause the film so far as it consists of the visual images to be seen in public, insofar as it consists of the acoustic portion, including lyric or musical word, to be heard in public without securing any further permission of the author or lyric or the musical work for performance of the work in public. In other words, a distinct copyright in the aforesaid circumstances comes to vest in the cinematographic film as a whole, which in the words of the British Copyright Committee set up in 51 relates both to copying the film and to its performance in public. Thus, if an author or a lyric or musical work authorizes a film producer to make a film of his composition by recording it on the soundtrack of a cinematographic film, he cannot complain of infringement of his copyright if the owner of the film causes the lyric or work recorded in the soundtrack to be heard in public and nothing contained in 13(4) of the Act on which Mr. Sen strongly relied on can operate to affect the rights acquired by the author of the film by virtue of 14(1)(c). Composer of a lyric or work, however, now let's see this, however, retains the right of performing it in public for profit or otherwise than as part of a cinema film and can't be restrained from doing so. In other words, the author composer of a lyric or musical work who authorized a cinematographic film producer to make a film of his work has thereby permitted him to appropriate the work by incorporating or recording it on the soundtrack of the film, cannot restrain the author of the film from causing the acoustic portion of the film to be performed or projected or screened in public for profit or from making any record embodying the recording of any part of the soundtrack associated with the film by utilizing such soundtrack from communicating or authorizing the communication of the film by radio dissemination, as section 14(1)(c) expressly permits the owner of the copyright to do all these things. So he has the right to show the film as a whole, not individual parts. The lyricist and author can't stop him. This is really what it tells. Then, my lord, other judgments come into play, and if your lordship turns the page, my lord, the other judgment considers entertainment network super cassette. Similar, my lord, question was not involved. And if your lordship then, my lord, turns to page 11, but halfway down the page, your lordship will find the wording of the words Copyright Act 1957 almost at the center.
Yes.
Not that sentence. Not in upholding the vices of the Copyright Act 1957, the court had balanced the proprietary rights of the owner of a copyright with that of the public by underscoring the availability of a claim for compulsory license. Garware Polyester, AR 89 Bombay, was a decision of the single bench. Plaintiff was the holder of a video copyright, whereas the defendant was a cable TV network which was transmitting the films. Not similar situation. The copyright of which vested in the plaintiff. Learned single judge analyzed and noted 2DD, which defines broadcast to mean communication to the public. Defendant's contention was that since the films were viewed inside private homes of various subscribers, it did not tantamount to a broadcast. Not same issue. Applying the ratio of several judgments delivered by foreign courts, the court concluded that even though the viewing of the subscribers may be within the privacy of the home, it fell within the ambit of the word broadcast as defined in 2DD of the Copyright Act 57. A single judge of this court in Super Cassette Industry versus Nirula, which I have not cited before, not earlier, which took care of it, not has applied this decision, granting an injunction in favor of the holder of the copyright against the defendant holder, which was showing these works through cable connection in the hotel rooms against public charges. So, now the division benches not applying this. The ratio of Northern India caterers was, however, not applied before our learned brother. We shall briefly refer to the decision of the House of Lords in Chapel versus Redwood to underscore that existence of separate copyrights in a singular piece of music is not a phenomenon unknown in law. Then, my lord, IPRS, my lord, abroad, Hawthorne's Hotel, English judgment, which was quoted in that other judgment, my lord, I had read to your lordship, my lord, is quoted. The only question which has to be decided in this action is whether performance of two works in public on November 20th was a performance of those two works in public. If it was, the defendants have infringed the rights which are conferred upon the plaintiff as owners of performing rights by virtue of Section 1(2) of the English Act. Then, defendants, this is all a quotation from Hawthorne's. The defendant's hotel is unlicensed. It has accommodation for 175 guests, and regularly for the past 4 years on Sunday evenings, the trio engaged on 20th November has played in the lounge. In addition to playing on Sunday evenings, it plays at tea time on Christmas and Easter holidays. On November 20th, 1932, a number of guests were sleeping in the hotel. Some of them were in the lounge. They were also present an emissary of the plaintiffs accompanied by a friend, not similar to us, detective present, who went there for the purpose of hearing whether there was any piece of music to the copyright of which the plaintiffs were entitled would be played by the trio. I think it's quite plain on the evidence that any member of the public who had given notice to the defendants of his desire to dine at the hotel on November 20th, 1932 or other Sunday would have been allowed to have dinner there, provided he appeared to be respectable. But I don't think we would have qualified in our younger days. No doubt, he would have been liberty to go into the lounge and listen to the music performed by the trio. In other words, any respectable member of the public who is prepared to pay the price charged by the defendants either for consuming the meal in their hotel or for staying there was at liberty to listen to the music performed by the trio. In my judgment, the performance by the defendants in those circumstances was a performance in public, and the rights of the plaintiffs which have under the statute have been infringed. The rights of the plaintiffs have been challenged by the defendants, and the plaintiffs are entitled to an injunction restraining the defendants, etc., etc. Suffice it to say that the amendments carried out in the Copyright Act are calculated to guarantee a fair return to authors, composers, and lyricists or sound recorders, as the case may be. There is no absolute, untrammeled, or unbridled right existing or granted to the public at large to enjoy the fruits of such creation without any payment in recompense for the payments in which the public may be willing to give. So, my lord, this is what it says, my lord. And then, Lord, there's another interesting portion, Lord, about 8 lines below that. We must not succumb. Lord, sentence beginning, we must not succumb to this indiscipline of entering into a detailed discussion on the legitimacy or reasonableness of the tariff for the simple reason that this question must be voiced and the verdict given by the authorities created under the Copyright Act. So, Lord, what it says is, irrespective of not what I'm charging, you don't like my charges, you don't like my tariff rate, Lord, there's a statutory mechanism, you go before the Copyright Board. And then, my lord, the viris is decided. Lord, the question of viris, your lordship will see, is formulated in para 17, because section 34 of the Act is arbitrary and unreasonable, as there are no guidelines for fixing of rates and no means of verifying or checking the reasonableness of the license fee, same as violative of Article 14. This was the point. Now, my lord, if your lordship turns the page, now the challenge is, my lord, set out in more detail, and that's interesting, my lord, and relevant in our case on the next page. Because the explanation to section 2FF of the Copyright Act holds any work made available to a guest in a hotel room to be communication to the public, which is contrary to reason. So this is one of the grounds of challenge. A person who occupies room in a hotel and accesses a work in private cannot be said to be a public place. Now, this is the exact argument being made. Accommodation provided to guests in a hotel comprises facilities and amenities that are availed of and enjoyed in the confines of the room. The explanation to Section 2FF, however, provides otherwise without any rationale or reason. A work enjoyed at home in private is no different from if enjoyed or accessed in a hotel room by the same individual. The unreasonable classification of hotel rooms as public places has allowed societies and copyright owners to claim exorbitant license fees, and the classification deserves to be set aside. So this was the exact argument which applies here, and that is rejected. But please see the next para. We are also not persuaded to take a negative view on the vires of the Copyright Act on the strength of the arguments addressed by Mr. Bhasin that the right of the objection has been deleted from the present Act. Act provides an adequate remedy in the form of alleviating process of compulsory licensing. Then, para 19. Petitioners challenge the vires of Section 13 of the Act, inasmuch as it provides that copyright was subsisting in the following classes of works: original literary, dramatic, musical works, cinematographic films, and sound recordings. We are in no manner of doubt that the categorization is founded on intelligible differentia so far as music is concerned. Broadly stated, most of the popular songs which may contain lyrics as well as melodies have been attracting different renditions which may have been performed publicly or recorded in a studio. The works of Western classical maestros such as Beethoven, Mozart, Gustav Mahler have been given expression by several philharmonic orchestras, all of which are entitled to copyright of their works. Popular musicians such as Beatles have had their work performed by several groups. Beatles are entitled to revenue of the original copyrights, and other musicians, orchestras are entitled to income from broadcasts of the unauthorized recording. The Copyright Board, as and when approached, will have to pronounce upon the vexed and complicated question of whether a consumer or recipient, if liable to pay copyright fees to the artist musician of a version recording, and in addition thereto, also holders of the original primary copyright. To borrow from the words of their lordship, copyright encompasses bundle of artists who at a given point of time may vest in different persons, etc. And then, my lord, the next para 20, we are unable to appreciate the strength or merits of any challenge to 2FF of the Copyright Act. These questions are no longer raised in dicta. We are in respectful agreement with the views expressed by the learned single judge in Garware Polyester and Polymer, which dealt with the question whether any publication occurs via broadcast through cable. Learned counsel for the petitioner has also contended that the fundamental rights of the petitioner under Article 19(1)(g) has been violated because of demands raised by IPRS. The argument is wholly devoid of merit and must be summarily rejected. Tariff charged by the Hotel and Restaurant Federation and the restaurants can come under similar challenge. It's wholly unregulated, etc., etc. It is wholly unregulated and to many seen as unrealistic, exorbitant. Now they are talking about what is charged by the restaurants in the restaurant. That is also unregulated. In a laissez-faire economy, such as what exists in India today, every person is entitled to claim any price for utilization of the rights or services. We are not dealing with essential commodities. If the government is of the opinion that the public at large is being exploited, appropriate legislation will be there, etc. So, Lord, these take care of it entirely. Lord, which leaves, as I said, Lord, two questions. Lord, balance of convenience, Lord, whether it is in favor of grant of injunctions. Here. Now, Lord, the law in relation to intellectual property has generally been that damages is not adequate, not remedy. And therefore, this is the proper and correct relief to provide. And this is now, well settled, right across all our high courts and the Supreme Court. Now, strangely, the origin of this, although applied to all intellectual property matters, actually started off with copyrights. So, it was held in the first, in the case of copyrights and then designs and gradually trademarks, that delay doesn't matter. That's one, one principle which is applied in interlocutory matters. Delay will not matter in intellectual property matters. It's a different question under 12A of the Commercial Courts Act. The picture has otherwise changed.
Even passing off, if you allow the other product to be in the market for 2 years, With knowledge.
With knowledge.
Yes.
With knowledge. That's not acquiescence. That's a different
That's
thing.
right.
Not
Acquiescence.
acquiescence would be a different thing. It's a defense. But the court say that delay is no factor, and because damages is not adequate relief, not therefore injunction is always granted in these matters.
Infringement delay may not be a consideration. In infringement of copyright, delay shouldn't be a consideration.
Not, if I may put it this way, not copyright, unlike not designs or patents, is not compulsory registrable. So, not any form of violation of copyright is infringement. I don't need to enjoy any registration at all. If I am the maker, I am the owner. Wrongful user in breach of the sections, my lord, is a infringement. Unlike trademark.
Trademark, I had in mind
Yes,
trademark.
yes. So, my lord, there's a little difference here. So, my lord, trademark also, my lord, not compulsory registrable, but if registered, it is infringement. If it's not, then it's passing off. But in copyright, registration not necessary. Any violation is an infringement of the right, statutory right given. So, my lord, this is the law which has grown up. My lord, we have decisions from the division bench, Delhi, division bench, Calcutta, and the Supreme Court saying all this. I'll just give you a lordship one. But in fact, the Supreme Court in one matter went so far as to say that in intellectual property matters, once a prima facie case is made out, injunction should follow as a matter of course, followed promptly by appointment of a commissioner. That's what the Supreme Court has said in such matters. So, this law has grown up around it. So, if my learned friend is in case he is going to argue balance of convenience, I'll just give you a lot. এতগুলো কেন দেবে? হ্যাঁ, ঠিক। কপি আছে? Oh, sorry, দিয়ে দাও। Not first, not one division bench judgment of our High Court. আরে ওই অ্যালার্গানে ওটা ভালো কোর্ট ছিল। আচ্ছা, okay, ঠিক। Well, if your lordship come to para 50, this was not early days for us in the profession, and division bench judgment not para 50. Now, this related to a design infringement and also copyright. Now, in relation to that, if I may not place para 50, we have no hesitation in holding at least prima facie that the designs of the respondent pens are imitation of the appellant's registered design and constitute infringement of copyright in it. When there is infringement of copyright, an injunction should normally be granted as a matter of course, as damages would not be an adequate remedy. But it follows another copyright case which was to do with infringement of copyright by import into India. And Castrol India versus Tidewater Oil, which is not a decision of our Calcutta High Court. This principle should be all the more applicable to the suit under Section 53, which limits damages to ₹1,000 only. And then, my lord, one Supreme Court judgment, my lord, very short and sweet because not there are any number of very large judgments, but this is just one line not for the proposition. If my learned friend argues in detail, I'll place the judgments. My lord. ঠিক আছে But in para 2, your lordship will find briefly stated facts as follows. Applicant filed a suit for passing off and for infringement of copyright. Then, my lord, if your lordship comes straight away to para 5, the law on the subject is well settled. In cases of infringement either of trademark or of copyright, normally an injunction must follow. Mere delay is not sufficient, etc. Grant of injunction also becomes necessary if it prima facie appears that option itself was. Not there are detailed judgments which consider it. I have deliberately not placed it. Not. আর কিছু বলার আছে? My lord, with that, my lord, if I may just take your lordship now, my lord, to the impugned order. মেমোটা এখানে দেখো না, মেমো আপিল কোন জায়গাটা আছে? আমার অন্য জায়গায় দাগ দিয়ে আছে। লেট মি জাস্ট পুল ইট আউট। ওটাতে একবার দেখো তো কোনটায় আমি দাগ দিয়েছি, আমার মনে নেই। ওটা একটু দেখো না। মেমো আপিল আলাদা করে থাকবে বোধহয়। Case 25 is not. ঠিক আছে ঠিক আছে এটাই কোনটা দিয়েছেন মেমো appeal না that if your lordship takes the order of 20th of September ওটাই দরকার Lord, Lord, the facts are recorded. I won't trouble your lordship with the first page. Lord, if your lordship then comes to the second page, the defendant, not the first para, Lord, rather the second para there, defendant has contested the injunction application by filing written objection, having denied the material allegations. Inter alia stated the injunction application as prayed for is not maintainable in law. Defendant categorically stated the suit is bad for misjoinder. Plaintiff has confused copyright and broadcasting rights and broadcasting reproduction right. The broadcasting right is a separate right under the Copyright Act, which cannot come within the purview of the Copyright Act, as has been held by the High Court at Bombay. I don't know what that means, because the broadcasting right is not covered by this act. I've showed your lordship. So it says can't come within the purview. Then section 37 of the Copyright Act defines broadcast reproduction right, and therefore it is different from the payment of any copyright in literary, artistic, or scientific work. The defendant do not play, perform, or communicate any music or musical work in its premises. One second. So, my lord, this is completely contrary to the two judgments I've showed your lordship. Communication of music, my lord, that is happening the moment you have that device, irrespective of whether it's played or not. Work in its premises hotel, so the question of taking or obtaining license from the plaintiff does not arise. The defendant is not involved in any alleged use of copyright music belonging to the plaintiff, and the defendant is not the user of the background sound recording work in its hotel premises. The act of the defendant in making TV sets available in its guest room along with an antenna or satellite equipment does not in any manner amount to infringement of Copyright Act. Now, my lord, please mark this. Lord, this is not one, a admission that he's providing it, not those detective reports and all that I don't need. He has these sets in the room. And my lord, the second is, this is clearly not contrary to the provisions of the Copyright Act and the interpretation given in the two judgments which I've given your lordship. The present application as well as the suit is speculative and misconceived and is fit to be dismissed. Now, my lord, the findings from here. On a perusal of the material on record and on perusal made by the learned advocate for the parties to the proceeding, it appears that as per documents, plaintiff is the owner of copyright subsisting in literary and musical works. So that much is found in my favor. And the defendant is running a hotel business. Regarding broadcasting of the music by the defendant from the TV set, the plaintiff filed his present suit and defendant denied the same. Plaintiff became confused over copyright and broadcasting right. But I'm the one who's got confused. On perusal, Lord, this is please see this. This is a conclusion without any reason. He says, I'm confused. That's it. Why? How am I confused? Nothing. On a perusal of the material on record coupled with the legal precedents placed by the parties to the proceeding, I am of the opinion that as per the provisions under section 37 of the Copyright Act, broadcasting right is different. And the plaintiff has no right to challenge the broadcasting rights in a suit. In this connection, the argument as advanced by the learned counsel for the defendant is totally justified. Now, what's the argument which is justified? Nothing. Argument is totally justified. Defendant has in its written objection stated that he has no involvement, as alleged, in use of copyright music belonging to the plaintiff. Now, Lord, where is all this coming from? So, prima facie, it is not in the hands of the plaintiff for granting of interim injunction in the favor. Other cardinal principle in relate to grant of temporary injunction is also not in favor. But there is no reasons at all.
What are the legal precedents?
Lord, maybe what's referred to in the notes which had been filed.
I see.
But not clear.
Not recorded in the judge order.
No, nothing. And Lord, these are only conclusions. There is no Lord reasons at all. And your lordship knows, Lord, reasons are Lord the backbone of any order. Lord, he simply says, I am confused. Why I am confused, I don't know.
No, plaintiff.
Hotel is only a confused character. It's not a broadcast.
Plaintiff is not entitled to maintain the suit because defendant says he is not involved.
Correct. And he admits I have TV, Lord, I have TV, I have dish antenna, I have everything to provide it, and I've showed your lordship the definition. It does not matter whether it is seen or not. Anything else to add? There's not nothing in the order I can deal with really. That's why I not showed your lordship what the law on the subject is, what the sections say. Sections will not give a clear ownership right over the lyrics and the music.
Did either of you appear before the learned trial judge? No. Nobody. Yes, anything else or shall we hear Mr. Mukherjee?
No, those are my submissions. But I was scared of placing the judgment first, which is what one normally does. But it had nothing, and it says we are confused. So I thought it's better not to start from a position where we are confused. So this is the situation. But I would respectfully submit, pass an order of injunction restraining them, and the usual thing will follow. What all hotels do, they obtain a license from us. But this is a hotel with a large number of rooms, not refusing to pay royalty, which he can't do anymore. But either he takes out the set-top boxes.
And a question we ask now in every matter: any chance of mediation?
But I'll just place my argument, Lord,
Well.
because Lord, their idea is to get Lord double benefit. Why I say this? For the same content, Lord, they are taking Lord the license fee from the broadcaster.
That's covered
Under the Cable Televisions Network Act, Lord, I'll give the reference to the rules. Lord, they cannot Lord broadcast anything without Lord first taking Lord the license from Lord the IPRs. But when the broadcaster Lord sends the signal, it doesn't Lord amount to communication to public.
It does not.
It does not. Because your lordship sees Lord a scrambled signal which is Lord delivered to the set-top box, descrambled, and thereafter Lord it is shown to the public, if at all, which Mr. Bachwat says, according to the judgment, mere presence of a television set will assume it is a communication to the public. Sure.
But could I have your lordship
Yes,
leave for 2 minutes?
Now, why I say this? I'm sorry, Lord, I am disturbing your lordship.
And you say they are charging from the broadcaster.
Because Lord, they are legally obliged to, and Lord, the law says that there cannot be any broadcast without Lord a license from Lord the content owner. I'll explain before your lordship, Lord, there are two types of broadcast. There might be one broadcast wherein Lord, let us say Lord, Sony has taken Lord a license for Lord broadcasting a particular cricket match. So Lord, it is an original content of Lord Sony broadcasted to me, Lord, the person who is Lord seeing it. Now, Lord, the copyright is vested with Lord the broadcaster. There is another Lord which the broadcaster pays a license for broadcast, and Lord, it is broadcasted Lord to the end user. This is the case which Lord they are making out here.
Yes.
So, Lord, for the same content, Lord, the broadcaster pays them the license fee. The license fee that is charged and paid is Lord for the purpose of broadcast. And Lord, the end user is Lord, whoever Lord is the last person who is a public Lord who consumes. Now, Lord, I'll just Lord place Lord the statutory provision. No, definition to broadcaster, communication to the public otateও আছে. But if your lordship kindly takes note of Lord Rule 6.6, Lord, এইরকম জায়গাতে আছে, আমি আরেকটা দিচ্ছি। হ্যাঁ,
Television network rules.
no, 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 এটা নয়। কি করছিস? Sorry. Oh, I'm sorry, my lord, it is 3. It is 3. 6-3. Broadcaster definition time আছে? Now, my lord, your lordship sees, lord, this is, lord, no cable operator shall carry on. Now, my lord, your lordship will kindly see the definition. But that is not the AIII. There are 3 definitions: broadcaster, cable operator, and Lord, page 4, internal page 4 of that. Lord,
Yes.
but, বই কিনে আনবেন না, দাম বেশি না, আইডেন্টিক্যাল বই কিনে।
Broadcaster, cable operator, and
Lord, the cable television network.
yes.
So here, your lordship sees, Lord, that there is a legal compulsion, rather I must say, an obligation upon the cable operator, my lord, to obtain the license from the owner, not, my lord, the broadcaster. The broadcaster is a different person. Under the scheme of this, my lord, this particular act, not a person, let us assume, my lord, Sony. Sony sends the signal, my lord, to Manthan. Manthan is a multi-system operator. From Manthan, it comes to my home. So the broadcaster might be, my lord, transmitting signals which are, my lord, owned by the broadcaster. Broadcaster might be, my lord, transmitting signals which are copyrighted. It comes to the multi-system operator, transmitted through, my lord, the cable television network. Because the cable operator means any person who provides cable service through a cable television network or otherwise controls or responsible for management and operation of a cable television network.
Here, Manthan is a cable operator.
just for an example, yes. Yes, they are not under the statute, they are called multi-system operators, MSOs.
Yes.
Now, it is the case of the plaintiff that there was not an investigator who was not planted in my hotel. He paid me lot for the hotel room. He recorded what was being shown in the television. He filed a report. And their contention is that it is a copyrighted content, what he could see in the television in the room that he had hired. Now, my lord, it was also his case that it was, my lord, through a cable television network. Now, my lord, the cable television network through which, my lord, the content has been transmitted, my lord, to the hotel and ultimately, my lord, communicated to the public according to my definition, reading of the definition. It was never made a party. So, my lord, the question here is whether IPRS, the plaintiff, they can charge, my lord, double royalty, my lord, for the same content, whether it is permissible under the statute. But in my respectful, my lord, submission on reading of the statute, but it is no.
Because you are saying for the same material,
Yes.
Manthan, let's say Manthan.
Lordship.
Manthan has already paid license fee or whatever it is.
Lordship. If they have not, then, Lord, it is for the plaintiff to charge them by saying that you have not paid my royalty. Because first of all, Lord, why I say this? Because when I pay to, Lord, the multi-system operator for the service, Lord, it assumes that the money that I pay is inclusive of what they are charging for their counter obligation to other persons. Now, Lord, another thing, your lordship will kindly.
Mr. Mukherjee, you will need some time, it appears.
Lord, I will.
Yes.
I will.
A matter is, hey, kota hai? 3:15. Mr. Joyanto Mitra is arguing a matter. He's sitting there.
Lord, I'll come back next Tuesday.
It will retain its position whenever. Even Thursdays we take up non-commercial first.
Come back, Lord.
If this is commercial, but if that list gets exhausted, we'll take up this one.
Lordship.
Lekho, Mr. Ranjan Bachawat, from a learned senior counsel appearing for the appellant, concludes his opening submission. Paragraph. Mr. Probal Mukherjee, a learned senior advocate representing the respondent, begins his argument but does not conclude. Paragraph lists the matter once again. We porshudine date diye daw. Comma retaining his position.
To concede could be artist Manush.
Double person action mein kar sakte. A great. Voice are Devi.
As an artist, I thought he is going to concede.
Are you still playing the Esraj?
No, I don't play Raj anymore.
No. Of course, you gave away your Esraj. Yes.
He's given it away.
I no longer play it. I've given it for a better use. In fact.
We can reveal
Oh,
that.
you've given up looking after the
Somebody,
welfare of artists. Income is coming from other sources.
দেখো ভিতরেই আছে ওখানে।
And nowadays law is music too. Much obliged.
Original side, not commercial. Fixed matter. Item number 84 to 90.
না দাও ওটা ফেরে হবে না।
Yeah. That's the judgment. Okay.
ডিসাইড করিনি এই স্যার মনে করেন না
আগে আগে জাজমেন্ট গুলো প্লেস করি করে তারপরে ইনফিউচার করতাম, কারণ আদারওয়াইজ মানে হবে না।
But, just to say, blood in item number 19 is a tag matter. But all of these matters are not involving the same or similar issues. But after my learned friend finishes, blood before your lordship
What
decides.
is your stand?
Our stand, blood.
No, because
Blood.
depending
Question
on
is transfer. Not question is transfer.
what Mr. Mitru is arguing is that Suomotu, the learned judge, could not have, and it is not mandatory. The court has a discretion.
Absolutely.
You
Not
have
that-
the same stand.
Absolutely.
Because Mr. S.N. Mukherjee will have a different stand, I
I
suppose.
see. I see. But I
You can argue after Mr. Mitru then.
very, very well.
You can argue before me, I don't mind.
There are others. There's Mr. Jishnu Shah.
The number of blood, I tell your lordship, in some other matter, not in another matter, blood, in fact, similar order had been passed by the same learned judge, and not in appeal, blood, that was challenged and that's been taken care of. I'll place. And blood, after the rules have been framed, blood, it's absolutely clear, can't be done.
And this is the same submission that I have been making. The rules have made it very clear. I mean, without the proviso, the things were won. Then the provisos have come in, and in the meantime, the rules have also come in. So, my lord, this the imperative nature of the main provision has been watered down substantially. So, keeping that in mind, my lord, to what extent, my lord, your lordship will please to, my lord, I will only respectfully cite before your lordship the Supreme Court judgments, which have influenced the learned trial judge, and rightly so, to come to the conclusion that he did. And my submission will be that perhaps the Supreme Courts do not say exactly, my lord, what has been said by the learned trial judge. My lord, the imperative nature of the provisions having been having gone, or I should say, having been watered down to a large extent. To what extent, my lord, we can take advantage of it? The discretion of the court is there. For reading the judgments of, I mean, the learned trial judge, it seems that his lordship was of the view that the court doesn't have much of a choice. But that is perhaps not correct. That is not correct. And particularly every time, my lord, generally the things are usual run-of-the-mill stuff. Usually, my lord, the run-of-the-mill stuff. So, my lord, same type of judgments can be sort of come in. But then again, I find, my lord, there are different types of problems coming up before the company court. This is one such, I thought. And my lord, I don't know, I'm just asking this question to myself, that if now the matter goes before the NCLT, how will the reliefs be granted to persons like us, those who have paid substantial amount of money in terms of the order of court? And then, my lord, not only me, my lord, the persons who have spent money on the security guards, the workers who have received a substantial amount of money from me, what will happen to them? They will stand in the queue once, my lord, the matter goes before the NCLT. So all these issues will come up. But, my lord, before that, yes, and perhaps, my lord, I will not be also in this, will not be able to stand in the queue at all. I will be completely a sort of pariah dog, moving outside, not being able to. This is something, my lord, lordship will have to consider. My lord, we are in the happy position of making our submissions and leaving it to your lordships. Thereafter, my lord, our responsibility goes and the headache of your lordship starts. Well, I shall leave it at that, my lord. My lord, kindly take a judgment, my lord. These are the judgments which I am sure my learned friends will rely upon. So, my lord, I am placing it before your lordship so that your lordship can consider the facts of this case. আমাকে কোথায় গেল? পালাচ্ছে কোথায়? বস। ছয় ধরবে, ইয়া কি হচ্ছে? বস। Where is Katie? আচ্ছা, অন্য কোথায় আটকে আছে না? আমাকে ক্যালিফোর্নিয়ার এটা আমাকে এটা খুলে গেছে, দেখো সব খুলে গেছে। জজ সাহেবের জন্য দুটো কপি আছে। My lord, I will just place first, my lord, 2021 two Supreme Court cases, page 641. This is, my lord, action is part versus sham metal, off-cited. Judge সাহেবের কাছে compilation রয়েছে?
নতুন করে দিল না?
Your lordship has been given a compilation. Your lordship have been given a compilation like this, my lord.
Yes, এটা compilation আছে, দেখো না।
এটা কি আলাদা? Compilation কি দেওয়া আছে জজ সাহেবকে? Then it will be easier for his lordship to mark it. হ্যাঁ। My lord, kindly come to page 10 of this compilation. This is, my lord, post winding up petition which has been filed. This is Rohington Nariman's judgment. Lordship will kindly come to page 645, running page, internal page 14. The judgment starts here. Kindly come to paragraph 2. This petition is filed. The order is dated 27th August 2018. This petition is filed under section 433E, 434 and 439 of the Companies Act. It has been pleaded in the petition that the respondent company had approached the petitioner company for supply of iron pellets. A specified quantity of so-and-so of the goods was supplied to the respondent company. After making partial payment, sum of which 4 crores 55 lakhs is due and payable by the respondent company to the petitioner. The respondent company from time to time issued 17 post-dated checks. However, 13 of the checks were presented to the bankers, were returned unpaid. Now, my lord, this matter went up, my lord, to the ultimately to the Supreme Court, and your lordship will kindly see para 1.2 at page 15. An application was then filed before the learned company judge by the State Bank of India, being a secured creditor of the appellant company, seeking transfer of the winding up petition to NCLT in view of the fact that SBI had filed an application under section 7 of the Insolvency and Bankruptcy Code, which was pending before the NCLT. By order dated 14 January 2019, the learned company judge transferred the winding up petition as prayed for as follows. And then the order has come. I'm not troubling your lordship. Kindly come to page 16. Section 434 has been quoted with all the provisos. And my lord, fifth proviso is also there. And then my lord, para 7. This court has already, in Rajni Anand versus Cosmic Structure, held that the power under section 434(1)(c) of the Companies Act for transfer of petitioner to NCLT is discretionary and has to be exercised in the facts and circumstances of the case so as to expeditiously deal with the proceedings winding up. In my opinion, it would be in the interest of justice and in the interest of the respondent company and the creditors that the matter be transferred to NCLT in exercise of the discretionary powers of the court under section 434 of the Companies Act. The order appointing the OL is a recent order. May I kindly note this. And not much time has elapsed since then. The OL has only taken steps to seize the office of the respondent company and the factory premises, and further exercise is yet to be carried out. The application is allowed as above. The present petition is transferred to so and so. So this is the fact which was, my lord, that which impressed the court. Then, my lord, Delhi judgment of action Ishpat that has been quoted. I am not troubling your lordship because action nishpat I shall cite before your lordship of the Supreme Court. Kindly come to para 3, Mr. Venugopal's submission. Sri K.K. Venugopal, Learned Attorney General for India, appearing on behalf of SBI, countered all these submissions. The submissions, my lord, of my lord Mr. Siddharth Luthra is contained in para 2. Shall I place para 2 once, my lord, your lordship looks into it, and then, my lord, I come to para 3. Siddharth Luthra, learned senior advocate appearing on behalf of the appellant company, referred to 3 judgments of this court. And then, my lord, judgments have been quoted, including Caledonian Jute, which I shall place before your lordship. According to him, none of the judgments apply to the facts of the present case, inasmuch as, on the facts in the present case, once a winding up order has been passed by the company judge, winding up proceedings alone must continue before the High Court, and parallel proceedings under the code cannot continue. He argued that Jaipur Metals makes it clear that even independent proceedings under the code can only continue when the stage is before a winding up order is passed, which was the case on the facts before the court. Likewise, in Forex also, the stage of the winding up proceeding was post-service of the notice of the winding up petition and before a winding up order was passed, as a result of which the 5th proviso to section 434(1)(c) of the Companies Act was applied. Likewise, in Caledonia, the winding up order has been passed on the facts of that case, the aforesaid order had been kept in abeyance. On the facts, therefore, 3 cases are entirely distinguishable and would have no application to a scenario in which the winding up order has been passed and the official liquidator has in fact seized the assets of the company in order to begin the process of distribution to creditors and others, which would ultimately result in the dissolution of the company. Sri K.K. Venugopal, Learned Attorney General for India, appearing on behalf of SBI, countered all these submissions. According to him, this court has unequivocally laid down that the 5th proviso to section 434(1)(c) of the Companies Act now makes it clear that a discretion is vested, so my lord, that is conceded. A discretion is vested in the company court to transfer winding up proceedings to NCLT without reference to the stage of the winding up. Even post-admission, according to the Learned Attorney General, if no irreversible step have been taken, then a combined reading of 5th proviso to section 434(1)(c) and section 238 of the code would lead to the result that winding up proceedings be transferred to NCLT, as not only is the code a special enactment with a non-obstante clause, which would, in case of conflict, do away with the Companies Act 2013, but also that given the judgment of the court in Swiss Ribbons versus Union of India, winding up is a last resort after all the efforts to revive the company has failed. Therefore, my lord, kindly see the basic argument, the foundation of the argument of Mr. Venugopal had been that if there is a possibility to revive the company, then perhaps, my lord, one need not go before the NCLT for the purpose of my lord, section 7 and section 14 proceedings. So this was the basis of the submission which was made, and my submission is also the same. That ultimately the purpose is to bring into the efforts to revive the company, and if that fails, then only the question of winding up comes in. Then, according to him, the discretion exercised by the company court and the division bench has been judiciously and correctly exercised, warranting no interference at our hands. Then, my lord, Swiss Ribbons case has been quoted at page 652 of the judgment and 21 of the running page. The Swiss Ribbons case, my lord, what has been referred to in Mr. Venugopal's argument. As is discernible, the preamble gives an insight into what is sought to be achieved by the code. The code is first and foremost a code for reorganization and insolvency resolution of the corporate debtors. Unless such reorganization is effected in a time-bound manner, the value of the assets of the persons will deplete. Therefore, the maximization of the value of the assets of such person so that they are efficiently run as going concern is another very important objective of the code. Thus, in turn, this in turn will promote the entrepreneurship as the persons in management of the corporate data are removed and replaced by the entrepreneurs. When therefore a resolution plan takes off and the corporate debtor is brought back into the economic mainstream, it is able to repay its debt, which in turn enhances the viability of the credit in the hands of the banks and financial institutions. Above all, ultimately, the interests of all stakeholders are looked after, as the corporate debtor itself becomes a beneficiary of the resolution scheme. Workers are paid. Kindly note this. The creditors in the long run will be repaid in full. Kindly note this. And shareholders oblique investors are able to maximize their investment. Timely resolution of a corporate debtor who is in the red by an effective legal framework would go a long way to support the development of the credit market. Since more investment can be made with funds that have come back into the economy, business then eases up, which leads overall to higher economic growth and development of the Indian economy. What is interesting to note is that the preamble does not in any manner refer to liquidation, which is only availed of as the last resort if there is either no resolution plan or the resolution plan submitted are not up to the mark. Even in liquidation, the liquidator can sell the business of the corporate debtor as a going concern. Therefore, my lord, I stop here for a moment. I submit to your lordship that if it is before your lordship, not before the NCLT, and if ultimately it is found that the attempt which is being made by the contributory for the revival of the company is not justified, is not acceptable, is not as it is expected of them, then my lord, nothing to stop the court from sending it to NCLT. So I submit to your lordship, why should my lord, if there is a possibility of revival of the company, why my lord, the court should also not exercise that particular function, perform that particular function in terms of section 466, because the purpose is the same, to revive the company. Then para 28, it can thus be seen that the primary focus of the legislation is to ensure revival and continuation of the corporate debtor by protecting the corporate debtor from its own management and from corporate death by liquidation. The code is thus a beneficial legislation which puts the corporate debtor back on its feet. Not being a mere recovery legislation for creditors, the interests of the corporate debtor have therefore been bifurcated and separated from that of the promoters, those who are in the management. Thus, the resolution process is not adversarial to the corporate debtor, but in fact protective of its interest. The moratorium imposed by section 14 is in the interest of the corporate debtor itself, thereby preserving the assets of the corporate debtor during the resolution process. The timelines within which the resolution process is to take place again protect the corporate debtor's assets from further dilution, and also protect all creditors and workers by seeing that the resolution process goes through as fast as possible, so that another management can, through its entrepreneurial skill, resuscitate the corporate debtor to achieve these ends. This is the purpose. Now, I am submitting to your lordship that if necessary, if the matter is before your lordship under section 466, there can be monitoring by the court, directing my lord the contributory who is seeking to revive the company to give report as to how the company is sought to be revived, so that the properties are not frittered away. It is not sold off for the purpose of my lord making personal gain. This can be done by the court itself. This is the purpose of NCLT. This is the purpose of my lord, IB court. And if that is so, the very same purpose this court can, why should it be transferred? And particularly when, my lord, This can be done without causing any inconvenience to all these parties who are standing in the line for the purpose of protecting their own interest. Those persons who have been paid, the personal security guards who have been paid, well, the corporate property is being protected in terms of the order of court. And your lordship has seen one after the other, the orders have been passed. Today, my lord, by so far as the my learned friends, Mr. Mukherjee's client is concerned, he had been pursuing its claim. Naturally, he is interested in getting back his money. So 434 crores or odd. So my lord, they voluntarily, deliberately, consciously, they wanted to stay out of it. And they said that allow me to pursue my claim before the DRT. They went before the DRT, stayed out of the winding up, allowed my lord all these amounts to be paid to make the company free of the debts for which my lord the applications for winding up were made. And thereafter, when they found that that was not doing much help to them, they came back and made an application under Section 7 of the under the IB code. This is, my lord, what I am submitting to your lordship. One is not entitled to, and I think, my lord, that is the reason why in the proviso to Section 434, the new Section 434C, that particular words have been made. Those who wanted to stay out of it. Language is very clear. Your lordship kindly sees, my lord, this is, once you say, I was just wondering, why is it that this language has been used? In 434, my lord, C proviso, the language that has been used is any party or parties to any proceeding related to winding up companies pending before any court. So any party or parties to any proceeding relating to the winding up is at the fifth proviso. And my lord, I submit to your lordship that the reason why it has been said is this, that this particular benefit has been given to a party who is before the court in the winding up, not to a person, my lord, who has gone out, voluntarily gone out of it. If one chooses to have his own remedy, by all means you do. Then you are not interested in saving the company. You are not interested in reviving the company. You go before the DRT for the purpose of recovery of your dues. And once you get it, then my lord, certificate will be issued. You pursue your certificate. And when the certificate is pursued, my lord, the properties will be sold. The company will go out completely. So a person who is not interested in revival of the company is not a person who has been contemplated under the provisions of the the IB code. This will be my very respectful submission. Otherwise, I don't find a reason why it is any party or parties to any proceeding related to winding up. And in no uncertain terms, my lord, two of the orders, one single bench, one division bench, have been recorded. That in so far as my learned friend is concerned, they wanted to stay out of the winding up. Then, my lord, kindly come to her. দেখিয়েছি ওটা দেখেছি আইপি মুখার্জি তারপরে তো আবার সঞ্জীব ব্যানার্জির অর্ডার রয়েছে দুটো অর্ডারই দেখিয়েছি আর ওটা রিপিট করবো না লর্ডশিপ will please to come to the operative portion of this judgment. All these judgments have been quoted. I showed to your lordship, and then in Caledonia has been quoted. I shall place it separately. Kindly come to page 659. My lord, the brief page 28, para 14. This is, my lord, the conclusion after considering all this. Para 14. What becomes clear upon a reading of the three judgments of the court is as follows, is the following. 14.1. So far as transfer of winding up proceedings is concerned, the court began tentatively by leaving proceedings relating to winding up of companies to be transferred to NCLT at a stage as may be prescribed by the central government. This was done by the transfer rules of 2016, which came into force with effect from 15/12/2016. Rules 5 and 6 refer to 3 types of proceedings. Only those proceedings which are at the stage of pre-service of the notice of the winding up petitions stand compulsorily transferred to NCLT. Then 14.3. The result therefore was that post-notice and pre-admission winding up petition parallel proceedings would continue under both statutes, leading to a most unsatisfactory state of affairs. This led to the introduction of the fifth proviso to section 434(1)(c), which, as has been correctly pointed out in Caledonia, is not restricted to any particular stage of a winding up proceedings. Then 14.4. Therefore, what follows as a matter of law is that even post-admission of a winding up petition and after the appointment of a company liquidator to take over the assets of a company sought to be wound up, discretion is vested in the company court to transfer such petition to NCLT. The question that arises before us in this case is how such discretion is to be exercised. So, my lord, one thing is clear from 14.1 to 14.4 that so far as pre-admission stage is concerned, as a matter of course, it can be transferred. It is, my lord,
pre-notice.
Pre-notice. And, my lord, also pre-admission. This, your lordship sees subparagraph 14.3. That is Caledonian, which I shall place before your lordship. But, my lord, after, my lord, the winding up petition has been admitted, post-admission petition, is that even post-admission of a winding up petition and after appointment of a company liquidator to take over the assets of the company sought to be wound up, discretion is vested in the company court to transfer such petition to NCLT. And then, my lord, how this discretion is to be exercised? After considering, my lord, all this, the court has said in para 25. And, my lord, the scheme of winding up has been given, the various provisions have been quoted up to para 24. Given the aforesaid scheme, well, para 24 is where company has been dissolved, such dissolution may be set aside within a period of 2 years from the date of such dissolution under section 356 of the Companies Act 2013. Given the aforesaid scheme of winding up under chapter 20 of the Companies Act 2013, it is clear that several stages are contemplated, with the tribunal retaining the power to control the proceedings in a winding up petition even after it is admitted. Thus, in a winding up proceeding where the petition has not been served in terms of Rule 26 of the Company Court Rules 1959, at a pre-admission stage, given the beneficial result of the application of the code, such winding up proceeding is compulsorily transferable to NCLT to be resolved under the code. Then next, even post-issue of notice and pre-admission, the same result would ensue. However, post-admission of a winding up petition and after the asset of the company sought to be wound up become in custodial ages and are taken over by the company liquidator, Section 290 of the Companies Act 2013 would indicate that the company liquidator may carry on the business of the company and so far as may be necessary for the beneficial winding up of the company, and may even sell the company as a going concern. So that power had been recognized. So long as no actual sales of immovable or movable properties have taken place, nothing irreversible is done, which would warrant a company court staying his hands on it on a transfer application made to it by a creditor or any party to the proceedings. It is only where the winding up proceedings have reached a stage where it would be irreversible. Again, my lord, the irreversibility is coming up. But as has fallen from your lordship, does it mean that until the properties of the company are sold, my lord, there is nothing to stop, my lord, the application from being transferred to that court. My lord, to that my submission is this: in the facts of this particular case, it might have been so. The properties have not been sold. In our case also, the properties have not been sold. It is, my lord, in the hand of the. But, my lord, irreversibility is not confined to the immovable properties of the company. Supposing, my lord, today perhaps 1 or 2 crores of rupees by way of, my lord, companies that the creditors' dues have been paid. Supposing, my lord, 200, 300 crores of worth of rupees had been paid off. Take this example. Take an extreme example for the purpose of testing this proposition. Supposing 200, 300 crores has been paid off to the creditors by the person who is seeking to revive the company under the Companies Act, my lord, before the court, with the company court. And then, my lord, suddenly the matter application is made for transfer. Can it not be said that a situation of irreversibility has arisen? Because that amount of money has been paid. Who is going to refund that amount of money? Once it goes before the NCLT, the my lord, COC, that is the Committee of Creditors, will come into the picture. My lord, an officer will be appointed for the purpose of. My lord, then only a chicken feed will be given.
Is not the kind of irreversibility that at least Nari yes. It is impossible to revive the company.
কোন প্যারাগ্রাফ গুলো একটু বার করে রাখো না।
তখন
ঠিক আছে, বলছি তো সিনিয়র হ্যাজ কাম, এসো এখানে। আমি অনেকক্ষণ বসে একটু দেখিয়ে দাও।
In the facts of the case, if the person who claims to be in a region of 400, 500 crore, that is something which is negligibly small. So negligibly small that it can be.
Correct. Yes, Mr. Smith.
Lord, kindly note the next few words. After it says stage where it would be irreversible, then comma, making it impossible to set the clock back, that the company court must proceed with the winding up. I am emphasizing on making it impossible to set the clock back. But well, after these amounts have been paid, I am just asking this question: where will this creditor stand? The person who is paying off the amount, he will neither be, my lord, he will not be in the category of either of the creditors. So, my lord, he will not be able to get this money back. File a suit or what?
He attempted a good thing, so as they say on a lighter note,
yes, ma'am,
he will get his reward in heaven.
Reward in heaven, yes, ma'am. I think that is the only thing that he will have to wait for ultimately. Because he will not be, my lord, either a operative creditor or financial creditor.
Provided, there's a proviso, provided he goes to heaven.
Yes. Well, if I may proceed on the basis of what has fallen from your lordship, my lord, if he does not give back the money, he will be, my lord, experiencing the experience of hell in this earth also, in this world. My lord, the point is this, my lord, what I am on is this, that the situation of irreversibility is making it impossible to set the clock back. I am emphasizing on that, making it impossible to set the clock back. And then, my lord, it goes on to say the court must proceed with the winding up instead of transferring the proceedings to NCLT to now be decided in accordance with the provisions of the court. Whether this stage is reached would depend upon the facts and circumstances of each case. Again, I am emphasizing on this. Well, in the light of this submission of mine, I would request your lordship, my lord, to examine the judgment of the trial court when I come to that. That will be the last submission that I will make before lordship. Paragraph 26. In the facts of the present case, the concurrent finding of the company judge and the division bench is that despite the fact that the liquidator has taken possession and control of the registered office of the appellate company and its factory premises, records and books, no irreversible step towards winding up of the appellate company have otherwise taken place. So what has been taken place? Nothing, excepting, my lord, the official liquidator taking possession and control of the registered office and the factory premises and the records and books, nothing more. So in that situation, the court said that the discretion should be exercised on these existing facts and circumstances of that case, that, my lord, no irreversible situation has arisen, which will entitle the court to send it to the NCLT.
No, if it is irreversible, then court may retain it with it.
If it is irreversible, that's sorry, my lord. Yes, the other way around. What is it in this particular situation, my lord? No irreversible, my lord. If no irreversible, or rather irreversible steps have not taken place, which will entitle the, my lord, the court to, my lord, to send it to the.
So in that case, it was sent by the lower high courts. It was sent.
Yes.
That was upheld by.
That is upheld by this. In the facts of this case,
yes.
Everything, my lord, will depend upon the facts of this case. My lord, this is one action ishpat that in the same year. My lord, that in the same year, reported in 2021, 4 Supreme Court cases, 435, the case of Navin Chandra Steel. That your lordship will please to find at page 34. This is also, my lord, by Justice Nariman. 40 decisions were cited, both of India as also of abroad. Lordship sees, my lord, the first paragraph. This appeal arises out of the judgment dated 7th February 2020 as corrected by order dated so-and-so by the National Company Law Appellate Tribunal. The appellant is an operational creditor, not a financial creditor, of the respondent number 2 herein, Sriram Urban Infrastructure, the company under winding up, and has a decree dated 7th October 2015 in its favor passed by the Bombay High Court in so-and-so. While order dated so-and-so, the division bench stayed the order dated 7th October and directed SRUIL to deposit the Indian rupees 14 crores with the protonotary of the senior master of the High Court or furnish a bank guarantee for the same, failing which the stay order would get vacated. The said appeal is pending as on date. We are also informed that an execution application being execution number so-and-so was filed by the appellant before the Bombay High Court. Then, sometimes in 2015, appellant filed a winding up petition being company petition number so-and-so against so-and-so before the Bombay High Court, the same being pending as on date. Then it has gone on to say, my lord, that different creditors have the different claims, 18 crores, etc., 15 crores and all. Then para 4, while this winding up petition was pending, India Bulls Housing Finance, a secured creditor of the company, filed a petition under Section 7 of the Insolvency and Bankruptcy Code before the National Company Law Tribunal, which was dismissed by NCLT dated so and so as being not maintainable as a winding up petition had already been admitted by the Bombay High Court. An appeal to NCLAT suffered a similar fate as the appeal was dismissed on 30th May 2018. However, on 6/8/2018, the Supreme Court admitted a civil appeal from NCLT order, which is pending as on date. Then, my lord, it has gone on to discuss various facts and well the submissions of the learned counsel that had been recorded. Paragraph 16, my lord, the judgment starts. Having heard the learned counsel for the parties, it is important to restate a few fundamentals. Given the object of IBC as delineated in paras 25 to 28 of Swiss Ribbons, which I place before Lordship, it is clear that IBC is a special statute dealing with revival of companies.
Sorry, which paragraph you're reading?
Well, para 16.
1/6.
1/6. Well, before that, the submissions of the parties have been recorded. Then, having heard, and Swiss Ribbon has been referred to, and it is clear that IBC is a special statute dealing with revival of companies that are in the red, winding up only being resorted to in case all attempts of revival fail. Winding up only being resorted to in case all attempts at revival fail, namely the Companies Act, which is a general statute dealing with companies, including Companies Act so and so. Then Allahabad Bank, Canara Bank has been referred to. Then various decisions have been considered. And ultimately, my lord, if your lordship comes to paragraph 23 at page 452 of the judgment. In Caledonia Jute and Fiber Private Limited versus Axis Nirman, this court decided as to whether a winding up proceeding in company court could be transferred despite the fact that the winding up order has been passed and then been kept in abeyance. This court in para 25 held that apart from providing for the transfer of certain types of winding up proceedings by operation of law, Section 434(1)(c) also gives a choice to the parties to those proceedings to seek a transfer of such proceedings to NCLT. This is under the 5th revised to clause C. It's kindly similar to the significance of the language. Section 434(1)(c) also gives a choice to the parties, that means parties to the winding up proceedings, to those proceedings, parties to those proceedings to seek transfer of such proceedings. Therefore, my lord, here again the locus standi of the petitioner has been considered. The court then went on to hold that in a winding up proceeding that has been admitted, since all creditors would be parties to such proceedings in rem, a secured creditor being such a party could therefore move the company court under the 5th proviso to Section 434(1)(c) of the Companies Act to transfer the aforesaid proceedings to NCLT to be tried as a proceeding under Section 7 or Section 9 as the case may be. Then Action Ishpat has been quoted, paragraph 14, which I placed before Lordship, that has been quoted in extenso. Then, my lord, kindly come to para 25.
Since all creditors would be parties to such proceeding.
A conspectus of the aforesaid authorities would show that a petition under Section 7 or Section 9 of IBC is an independent proceeding which is unaffected by winding up proceedings that may be filed by the same company. Given the object sought to be achieved by IBC, it is clear that only where the company in a winding up, is near corporate death, that no transfer of winding up proceedings would then take place to NCLT to be tried as a proceeding under the IBC. Short of an irresistible conclusion that corporate death is inevitable, every effort should be made to resuscitate the corporate debtor, in the larger public interest. which includes not only the workmen of the corporate debtor, but also its creditors and the goods it produces in the larger interest of the economy of the country. It is thus not possible to accede to the argument on behalf of the appellant that given Section 446 of the Companies Act 1956, Section 279 of the Companies Act 2013, once a winding up petition is admitted, the winding up petition should trump any subsequent attempt at revival of the company through Section 7 and 9 of the petition under the IBC. Well, if I may read this sentence again. It says, it is thus not possible to accede to the argument on behalf of the appellant that given Section 446 of the Companies Act 1956 and Section 279 of the Companies Act 2013, once a winding up petition is admitted, the winding up petition should trump any subsequent attempt at revival of the company through Section 7 or Section 9 of the petition under IBC. In other words, what it says is this, that the court will not countenance a submission, an argument that once a winding up petition is admitted, then Section 7 and 9 is to be kept out of consideration. The court says that even after winding up petition has been admitted, Section 7 and Section 9 of the petition can be considered by the court. So, my lord, again we come back to that particular provision. The court will have to exercise discretion on the basis, on the facts and circumstances of this case, and my lord, considering as to what stage it has been has reached. And my lord, the stage is such that an irreversibility has taken place, which will entitle the court to retain it in the company court and not, my lord, transfer it before that. So, my lord, all these judgments are, my lord, to the same effect. Lordship will kindly come to then after quoting Section 230.
Mr. Mitru, particularly this judgment, this irreversibility is almost certain corporate death.
Almost certain corporate death. In a situation like this, in my situation, my lord, I am, my lord, applying this principle to our case, where, my lord, again, my lord, I just draw your lordship's attention to page 177 of volume 2. This I submit to your lordship that absolutely, your lordship is, if I may say so with great respect, absolutely correct, that the issue is, has a stage been reached in the facts of this case where the company has to be put to sleep? If so, then instead of putting the company to sleep, you approach the NCLT to revive the company. And in the facts of our case, my lord, when your lordship looks into page 177, see, my lord, all these amounts have been paid. If these amounts have been paid, or, my lord, attempted to be paid, substantial amount has already been paid, then, my lord, it is not a situation where it is inevitable that the company should go into liquidation. And if it is not so, then, my lord, can I not argue that the stage of irreversibility has not arisen?
If it has not arisen, then the argument is send it to NCLT for its revival. If it is almost dead, almost certainly die, nothing can be done, don't send it. There's no point. Keep it with you, High Court. Finish off the winding up proceeding, kill the company, because it has to die.
No, but, my lord, attempt is, my lord, to revive the company. I am on the purpose of NCLT. Purpose is to revive the company. So, if the revival can take place in the court, in the High Court, before your lordships, then why should it be this additional exercise?
Because a special enactment has been brought by the Parliament for revival, which perhaps would not permit the High Court. I don't know.
Then
if there is a chance of revival, send it. That is a special mechanism there for revival, send it. But if there's no chance of revival, near almost certain corporate death, then what's the point? Don't send it. Let it die here. This is what, as of now, appears to both of us.
Yes, maybe you are right. Your lordships are, maybe your lordships are right. But I will submit to your lordship in the facts of this instant case. Can I not say, my lord, that if my client had gone out, my client had not been there before the court, then, my lord, what would have happened? The company would have been sent to death, certain death. But now, in so far as the company is concerned, these parties, this particular party has come up and has paid off all the, for what purpose? I ask this question to myself. For what purpose has he paid the money? Not, my lord, to do a charity. Not for the purpose of revival of the company only. For the purpose of, my lord, reviving the company and, my lord, to run the company. That is the purpose of the scheme. My lord, I just logically I say that will it not be a certain amount of absurdity will come in, that a person had been allowed by the court order to pay off the debts to revive the company. And then the court says that I ignore all these facts. I send it before the NCLT for the purpose of revival. And revival takes place under the provisions of the IB code. So all this exercise, what has taken place, all this endeavor which has, my lord, been undertaken over the years, they, my lord, are completely, well, kindly note, and this very important thing, that my client, after this, I will not be able to go before the committee of creditors or before, my lord, the person who is in charge of, who will be in charge of the company, and, my lord, stand in the queue, because I will not be a creditor, neither operative creditor, not, my lord, financial creditor. Then where do I go? So will your lordship not take note of that fact? Yes, what is falling from your lordship is, if your lordship strictly takes, my lord, the language of the section, I submit to your lordship, my lord, there is some amount of incongruity comes in. You revive the company at the cost of a person who has made the attempt to revive the company in the company court. Now, then you ignore him altogether and you say, I forget about you. The revival has to take place through the IBC.
May sound unfair. May sound unfair.
Not only it is unfair, it is, my lord, illogical, and it is unethical. If I may say so with the greatest of respect, my lord. And I am repeatedly asking this question, my lord, to myself. I am not being able to find any answer. What will happen to my client? What will happen to my client? You revive the company and you put my client to death. He will never be able to recover this amount of money.
Did the court direct you to pay, or you offered to pay?
My lord, the court, let me put it this way. When, my lord, the company winding up proceedings were pending, and, my lord, the company was unable to pay the debt, I came in and I said that I shall pay. We paid. That was recorded by the and, my lord, the assets of the company was directed to be made over to my client.
Is there no observation that this will not create any equity in your client's favor?
No, of course not.
Nothing of the kind.
There is not.
Any timeline within which payment was to be made?
Lordship?
Any timeline for the payments to be made?
Well, as and when, my lord, as your lordship knows, my lord, in the company court, when the matter comes up for hearing, and the court gets the report.
So both act voluntarily, but will court direction.
My lord, kindly come to page 103, first volume. Two petition created. Well, kindly come to page 102. এখানে অ্যাপ্লিকেন্টটা কে ছিল? Page 102. This is an application by one Shujit Dottoray, a contributory of Indo-Wagan, my client, under section 466 of the Companies Act. He wants the winding up order against the company to be set aside and the company to be revived. It may be noted that at the time the winding up order was passed on 6 March, no secured creditor appeared before the court. The applicant has settled the claim, my lord, applicant meaning thereby my client, of the petitioning creditor at rupees 10 lakhs. His learned counsel, Mr. Gupta, produces a demand draft for the amount to be handed over to the petitioning creditor. There is another petitioning creditor represented by Mr. Ms. Manali Bose. This winding up application is admitted on 3rd January. The principal claim was rupees 28 lakhs with interest is over 13 lakhs. Mr. Gupta has brought a demand draft for rupees 4 lakhs as part payment of the claim of this creditor. There are other two petitioning creditors. Their winding up application numbers are so and so. In that first company petition, the outstanding sum is rupees 8 lakhs and odd, the principal amount, whereas the second company petition, the claim is rupees 18 lakhs and 24,000, the principal amount. The contributory has brought demand drafts of rupees 4 lakhs each to partially satisfy the claim of these creditors. It may be noted the claim are also admitted by the court. Then for official liquidator submit, the official liquidator has taken possession of the company in liquidation and deployed 36 security guards and 3 armed personnel. Mr. Gupta is permitted to hand over the demand drafts to all the petitioning creditors. They are permitted to encash the same without prejudice their rights and contentions. Since the amounts of payment now made to the petitioning creditor are not very significant, for the time being, the official liquidator will relinquish physical possession immediately but remain in symbolic possession. I make it clear that the company might resume business under the aegis of the official liquidator. So the court is, my lord, giving its blessings. The security guards deployed in the registered office and other establishment of the company will continue to be deployed until further orders. The official liquidator will also take symbolic possession of the other establishment of the company and deploy security guard. The expenses incurred by the official liquidator in providing security guard will be borne by the contributory and to be paid to the official liquidator by 31st May 2017 and thereafter to be paid on fortnightly basis. The applicant will also pay the legal costs of the official liquidator assessed at rupees 20,000 per month. And the applicant is directed to bring demand drafts on the same amount in favor of the said creditors on the returnable date. So, my lord, under the direction of the court, I had been going on paying, and the court is recording that. And my lord,
page 100. Page 100.
Your lordship will please to come back to page 100.
Indo-Wagan is a limited company.
Yes.
Who is Shujit Dottoray?
I think, my lord, the person who affirmed the petition, and my lord,
This is an application by Shujit Dottoray.
No, not really. It is by Indo-Wagan. With, my lord, kindly see that Indo-Wagan Engineering Limited was there.
And Indo-Wagan. Cost and Indo-Wagan. So
and no
affidavit যেহেতু এখন
এবার দেখে নাও, মানে সুজিত দত্ত will have not the capacity to make payment. And my lord, in terms of this, your lordship will please to see that and my lord, that this is, your lordship will please to see the order is which I placed before your lordship is dated 18th May 2017. Subsequent order is 17th August at page 100.
When was the winding up order passed?
Winding up order was passed. I shall give you a lordship date.
March 2017.
6th March 2017.
And the order impugned in this appeal?
Order, I shall come to that.
No, when was it passed?
That was passed much later.
4th July 2020.
24.
22 minutes.
4th July 22.
payments were
after.
made in between also, 2017 to 2022.
Well, the matter was pending, man. Matter was pending until, my lord, an application for transfer was made.
You're running the factory.
Not really, because well, the official liquidator was in possession of the factory. I was in possession, official liquidator was in symbolic possession. And the police,
We set up, we filed application.
well, police barracks have been set up there inside the premises, and my lord, application was made for removal of that police barracks.
Which is pending.
And that is also pending before the court.
Where is this factory?
এটা কোথায় এটা ফ্যাক্টরিটা?
Joshua.
But at Jessore Road, near the airport, I am told. Must have been in vast land.
So with the police barracks now it has become Barrackpur.
Yes, really. Well, kindly come to page 100, this subsequent order of 17th August 2017, the earlier page. Earlier page was subsequent order. The earlier order was, my lord, May 2017, and subsequent order 17th August.
It has to be taken.
My lord, the first paragraph I have already placed before lordship. So and so for the secured creditor, that is for whom, my lord, Mr. Mukherjee is appearing, submits that a client wants to stay outside the winding up proceedings and pursue their claim otherwise in accordance with law. Hence, it has been taken that the secured creditor, Edelweiss Asset Reconstruction Company, has no objection to the setting aside of the winding up order. A person who is, my lord, seeking setting aside the winding up order, staying outside, pursuing its, my lord, remedy in a different court, before a different forum, my lord, comes up with an application under section 7 thereafter for the purpose of transfer base. And I submit to your lordship. Then, my lord, next paragraph, considering the fact that the applicant has been making periodic payments to the petitioning creditors as mentioned in the order dated 18th May, the said order to continue until further orders. Then next page, Mr. Gupta's client is directed to formulate and bring to this court a scheme for payment of the balance outstanding dues to the creditors, with a copy circulated to the advocate on record for all appearing parties to enable the court to pass an order vacating the winding up order.
As on date, everything has
Was this done?
As on date, my lord, I am told everything has been paid. What has been, my lord, said?
Everything has been paid.
Everything has been paid, including, my lord, the workers. So, my lord, now what is
Company has no debt now.
I'm a secured creditor, 400 crores odd.
That's not my learned friend. He is outside. I am not touching. He is, my lord, untouchable. He has gone
He
up.
has not made his claim with the OM.
He has not made his claim before the official liquidator because he wanted to pursue his remedy otherwise.
What about the security people?
Security people, outstanding, my lord.
Expenses is pending, my lord.
How much?
4 crores and odd, my lord. For the security agency, my lord.
You are the security agency.
I'm not led by Mr. Mitesh.
4 crore.
They are not. They are not, my lord, creditors before the winding up. They are not, my lord, creditors. They are, my lord, creditors who had, my lord, cropped up in course of winding up. They are not, my lord, creditors before the winding up. Winding up order, my lord. There were more than one application by way of winding up. And, my lord, all of them, the creditors have been paid, I am told, including, my lord, the workers. Workers are standing, my lord, in the queue before your lordship. Now, my lord, if it goes before the IBC, then, my lord, my learned friend's client will take the cream out of it. 434 crores. What had they been doing before the debt recovery tribunal? They wanted to stay out. They pursued their remedy before that. They took a risk. I could have understood, my lord, they had remained in their winding up proceedings and then pursued their claim.
Hasn't the DRT passed a decree in your favor?
Yes.
The And you-
recovery certificate after the original application is disposed from. After the original application was disposed of, they've got a recovery certificate which they are pursuing before the recovery officer. That recovery certificate is
At page 34 to 40.
Is of some vintage now. On the basis of that, after the transfer order is made by this honorable court, on the basis of that recovery certificate, they file a section 7 application for initiation. So they ride on both. In fact, on 3. This order, please, here the security creditors were directed to be paid by the.
They did
They
not
didn't
pay.
comply with this court's order.
একটা প্লেস করেছে আর একবার দিচ্ছি
21st, 178, so volume 2. So Mukherjee's client has to pay for his asset being protected.
Just to plan out our proceedings, how much time we should keep for you on the next day, because it's almost today.
I have almost, I shall just place two paragraphs from Caledonian Jute and the impugned judgment.
Right. So, and then who will address? You are assisting Mr. Mitru.
He's for the workers.
Mr. Shah.
Mr. Shah.
Very well. You are led by Mr. Shurujit Mitru. Very well. You are all.
There is a tagged appeal of Mr. Bachawat.
Yes.
There's some appeals which were tagged.
Daku.
But before your lordship concludes today, only one paragraph I want to show to your lordship at page 178.
Yes.
Page 178 in the second volume.
Second
that was
volume.
the division bench.
170.
Well, this was an appeal by the security.
Yes, this we have noted, Mr. Mitru, according to the same effect.
My lord, kindly see, kindly come to page 180. Not a penny has been paid in terms of this order.
By Edelweiss, by the applicant.
180, third paragraph. Notwithstanding the two secured creditors of the company in liquidation not submitting to the liquidation proceedings, it is apparent that the assets protected by the official liquidator may ultimately be taken up by the secured creditor as a part of the security. So, my lord, their existence has been recognized. Thus, the protection of the assets is in the interest of the secured creditors, and the secured creditor must bear or at least share the expenses therefore.
Not a penny paid.
Nothing has been paid. My lord, this is in Bengali, we call it, my lord, gachero khabo tolaro kurobo. And this is exactly what has been.
The defaulting compliance of this order.
First or second? Kindly consult your diary.
Either of these, your lordship.
Lord, first, my lord.
Okay. Mr. Ghosh, who is that?
My lord, Mr. Banerjee, my lord.
Oh, Mr. Banerjee, I see.
Which Mr. Banerjee?
First, you want on the first?
Yes, my lord, if it's possible, my lord.
Doesn't want it to be transferred.
Yes, my lord, we want it to be transferred.
First?
Yes, sir.
Mr. Jayantakumar Mitru, learned senior counsel representing Indo Wagon, resumes his argument but does not conclude. Paragraph as agreed upon by and between learned counsel for the parties, list this matter once again on September 1, 2025, marked 3:30 p.m.
On the next day, my lord, either myself or my lord, Mr. Thakkar, who is more ready in the matter.
You.
Yes, sir.
Well, if I shall be sitting next to him.
Yes, okay, please come.
Yes.
Sit next to him, he will argue.
Yes, I will come. Otherwise, my lord, financially, I will be deprived.
Sure.